What we advertise judgment was raising. What to be listed before. Chamber it was saying. All right, let same. It's already not a order was there, Milan, by inadvertence share typed and with signature and release that order. It is okay. All right, in view of order dated 2/11/2022, judgment dated 2/11/2022 passed in MFA number 6. Wait. This is the order sheet. This judgment was correct. I've been a wrong file. I did a wrong file. They have typed here only. So it has to be recalled. It has to be recalled. I'm not disabled with this. Not. All right. Your appeal has already been decided, right? Fine. We have perused the record order dated 2/11/2022 is hereby recalled. Right. Nothing is to be done. Judgment has been delivered. In another matter, I if I said here I had appeared in yes.
In this case, we are praying for a week's time. The reason is the Gratuity is free from
Week's time.
yes.
Comply with office objections, failing which appeal shall stand dismissed without reference to bench. Week's time is granted to comply with office objections, failing which we are granting 2 weeks time peremptory. 2 weeks peremptory.
But in this case, I represent the first respondent who died, Milad. I undertake to file wakalat on behalf of the in-laws of the first respondent, Milad, if he provides me a copy, application copy, Milad. By next week itself, I will file my wakalat, Milad.
SV Bhatt Learned Counsel undertakes to file wakalat on behalf of LRs of disease respond number 1. What? Respond number 6 or 1? 6.
Respondent number 1, Milad.
One and process steps to be taken for service of notice on respondent number 6 within 2 weeks, failing which appeal shall stand dismissed for respondent 6. What? This will be held sufficient, right? The service of notice on respondent.
Refused.
Ah.
Just to make it again.
Refused. So has to be in view of the acknowledgement contained in posting Shara that respondent has refused to accept notice, service of notice on respondent is held to be sufficient. Like the appeal is admitted for hearing, notice record. So appeal is admitted for hearing, then say record. 2 weeks peremptory. 2 weeks peremptory. To delete the name of
My lordship, serial number 9.
2 weeks peremptory.
My lordship, serial number 9. My lordship.
2 weeks to comply the office objections, sir. Peremptory order.
Pray for 2 weeks time.
You better argue on review. What is it? Publishing of copies. All right. 2 weeks. 2 weeks peremptory. Fix peremptory.
In this
2 weeks.
no, you have complied.
The red counsel for the applicant submits.
Objection can be overruled. The reason I mentioned.
The red counsel. What office of
The objection is at page number 112, annexure F. The labor court has shown it as WW3.
all right,
It should be
after
WW2.
hearing the red counsel for the applicant office objection is ignored.
Please, much.
Weeks peremptory. 2 weeks peremptory. Memo has been filed seeking leave of the court to withdraw the appeal. The memo is taken on record. The appeal is dismissed as withdrawn. Cost. You are withdrawing the appeal, right? Memo for withdrawal. So what 50,000?
Single digit order for single digit order for
50,000. Survey counsel for these parties jointly submit that this intra-court appeal has been filed against order dated so and so. Learned counsel for the applicant while inviting the attention of this court to judgment dated to the learned counsel for the appellant while inviting the attention of this court to compromise arrived at between the parties submitted that the appellant seeks leave of this court to withdraw the appeal as the matter has been amicably settled. It is further submitted that the requirement of deposit of rupees 50, that since the matter has been amicably settled, comma, the requirement of deposit of rupees 50,000 as cost be dispensed with paragraph in view of a court's submission. Reason assigned in the memo and taking into account the fact that the dispute has been amicably settled between the parties, order dated so and so passed by learned single judge insofar as it pertains to direction to pay the cost of rupees 50,000 is set aside. The appeal is in view of amicable settlement between the parties. The appeal is disposed of in terms of compromise arrived at between the parties. That's the idea. To get the cost. Huh? Infructuous. Learn it count. Huh? He says infructuous. Why? Huh? Huh? Why it has become infructuous, madam? Why is he saying infructuous? Though he is unable to explain, but you tell us why it has become infructuous. Refund the salary to the petitioner to have deducted. So salary has been refunded. Weeks time, peremptory. Weeks time, peremptory. 2 weeks time. Comply with office of peremptory. And some we don't, madam, it's a matrimonial dispute, you understand, right? Definitely, we are 100% sure that she will refuse to accept, he or she, whosoever. Why to get into that controversy? And then again, we will hear you deliver judgment, then application for recall that it was never served on me. Your husband, right? So when you celebrate your second marriage, she will rush to the court saying that my husband is getting married. I did not know. Why to get pay process fee?
criminal case also may happen.
Another criminal, my lord is saying, another criminal case may be filed against you, 494. Why get into all this trouble? 2 weeks. Weeks.
But 19,
What date? Affixed. Where it is, it can't, date cannot be affixed on a wall. Fixed, fixed. So when, you tell us, when will you argue? 9th month, Mr. So get it. Why 10 days? No, this is preventive detention, Mr. Every day counts. You cannot have a laid back sort of an attitude in these cases. And let him suffer it out. He is in jail. We will enjoy 10 days then. And you seek adjournment also. We have noticed these people seek adjournment, not well, medical emergency and all that. This all should not happen. It's a Article 21 is at stake. Without trial, he is in jail. And we know for what for. He must be a thief. Repeatedly 15 FIRs and you put him behind the bars. This is the law. That's why the police authorities adopt a via media and put him in the jail. He can be tried under the ordinary law. No reason. We are fixing. Wednesday. 23rd. Learned Counsel for Learned Additional Government Advocate prays for short accommodation. You prepare a synopsis, Mr. If you want. Don't tell us that this crime number, this. Prepare a chart. Learned Counsel for the petitioner prays for short accommodation. No, Learned Additional Government, the SPP. Prays for a short accommodation to enable him to produce the record pertaining to detention of the petitioner. List on 23rd November 2020. Yes. Furnishing of PF. Well, Learned Counsel for the applicant submits that the process fee. Yes, process fee has been furnished on 19/11/2022 in view of a process submission issue notice.
Readdress.
Huh?
Readdress of this.
Okay. Issue notice to respondents. Learned Counsel for the applicant submits that the respondent. Learned Counsel for the applicant has filed a memo seeking just his appeal, right? He will face the music. Huh? No, what did you do to get the case listed in case you are suffering? And in case you are suffering. So our short, this thing is, question is, what did you do to get this case listed? Learned Counsel. Learned Counsel for respondent number 2 has filed a memo. Learned Counsel for the applicant has filed a memo seeking leave of seeking dispensation with requirement of service of notice on respondent number 2 on the ground that respondent number 2 was expert paragraph in view of a process submission requirement of service of notice on respondent number 2 is dispensed with. Office objection is ignored. What is 3 of 22? Non-compliance. Who has filed? A week's time is granted to comply with office objections on IA 3 of 22.
This application is
2020 and 21 I would have wasted my has dawned upon me. To keep quiet, what to And for our sake of our. Yeah. Huh?
That's usually this one, the highest.
They want- This is a matrimonial dispute.
So matrimonial case only mar regard only this case not only regarding no only present pension.
You are a husband or wife.
He alleged the second wife or he not entitled to any pension. During pregnancy, husband died. Only now entitled for pension of the husband. My I have
This
to wife.
MFA has been decided. The judgment is there 16th April 21.
But in this case, man, there are two suits pending before the
Just a
House Court.
Just this appeal has been decided, right?
Yes, not decided.
Then what in pleading?
Not during pendency, man, the appeal of respondent died. During pendency of appeal. Only now he worked as a education department,
Who died?
education department. Not only pension is entitled to wife. The limited scope is in the appeal only pension regarding wife.
1 minute. You are not prepared to help us what to do. We will have to see ourselves. You cannot even explain to us what is it. We will have to help ourselves. Thank you. Please sit down and relax. This appeal has already been decided, Mr. Nataraj. Why it is, how can in a disposed of proceeding an application for impleadment would like? Yes, sir. You have done, you have prepared the case, you have told us how well prepared you are. Now who will pass an order? The problem is, we can't ask you to pass an order. We have to pass an order. So we are little slow in understanding. So this appeal has been decided. What happened? Recalled. Recalled. Why? Why it has been recalled? But he died. That is 2 days. Saturday, Sunday, you didn't go to.
Saturday, I can leave.
Oh, that's right. This judgment has been recalled, right? What is the decree passed by the family court? Family court, what is the decree?
Dissolution.
Dissolution of marriage.
Dissolution of marriage.
What?
Yes.
Resolved by decree of state. This person circumvent Sufi, whatever. Person not a party to the decree cannot challenge.
Pleading application.
Respondent. So decree and permanent alimony, right?
Yes, sir.
What?
Why the impleading applicants want to come on record? That we know. Please answer the court question. Why these applicants are interested to come on record? What is the order? This court has directed you to file an application. See? Who are these impleading applicants? Who are they, mister? Can't you understand English? How you are entitled to come on record? What legal errors? It's a decree for dissolution of marriage. What legal errors? What is the existing right here? How you are entitled to contest it? The appeal abates. There is the question of the dissolution marriage because the husband has died. What is there for you to contest in this MFA? What is there for you to contest in this appeal after the husband dies? We are not concerned about that here. In the review, it is the order has been recalled and the MFA is now before the court. Now tell us as to how you are entitled to come on record. How you are entitled to come on record? What rights?
But you won't tell us, right? You have not read the order passed in review. What is it? Tell us. Why read? What is there to read? You are here to assist us, right? If we have to read everything, then there is no need. You go out, then there's no need. Why should you appear? If we have to find out everything ourselves, tell us why. You have understood the question, or should we appoint an amicus to help ourselves? You have understood. So don't read, close the file and tell us why it should be, why your application for impleadment should be allowed. You have not read it. Don't read. Tell us what has been held in review. What has been held? You have not read para 6, right? You have not read at home, right? So tell us then why it is necessary. You tell us what is it, para 6?
How does this appeal survive? First of all, tell us that. Respondent's husband has died. Decree is only for dissolution of marriage. What is there now to hear it?
If you are agreed, file a suit. Independent, if you say that you are the widow of that person, right? File a suit seeking a relief. Fine. There is no ground. Tender? Tender? What tender? No, whatever you get a declaration. They have done only to get the benefits of in service, service benefits. What do you say?
Not inspect of legal hears not. The suit are two suits are pending. 3 of 2010 and 257 of 2005 regarding LRs. These responses are party before the suit. But in the review petition, there is an order to consider.
Respondents, they have modified the suit. Let's seek the declaration. So your appeal will be dismissed.
But appeal appeal the LR is son is implemented as LR. Note on appeal is not abated. Already LR is application filed, LR application allowed. And son is implemented, formal implemented as a respondent. Regarding status of the son. On 9/4/21.
Heard on IA 1 of 21 for the reasons assigned. We have heard learned counsel for the parties for the reasons assigned in IA 1 of 22. Same is allowed. Let amended cost that will be filed within a week.
Your application is allowed.
Year number 4, 5, and 6. To bring the LR, this is the respondent number 15A. That he has been.
Notice has been issued. No.
5 and 6.
Nobody is appearing.
Served and under.
None appears for the proposed LR of this respondent number 15.
15A.
So IA 4, 5, and 6 is allowed. Order IA 1 of 21 delay in filing the application seeking recall. For the reasons assigned in the application, duly supported delay of
Appeal was withdrawn.
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 For
by the appellant. Appeal was withdrawn.
one, it's a recall.
Now the
Also delays condoned IA is allowed. That reasons assigned duly supported order dated so and so recalled. WA is proved to file, then those 3, 4, 5, and 6 of 21 allowed. Amended cost that will be filed within 2 weeks. What short? 3 years is not short time. Huh? Oh, you have recently been served. So another 3 years for objection. How much time? The right counsel for respondent praise fund is granted 2 weeks time to file reply to IA 1 of 2019 and 2 of 2000.
And for the appellant, madam, there is a delay of 51 days delay, ma'am, in
Respondent objections have been filed.
not filed.
Let objections, if any, on behalf of respondents to IA 1 of 19 and 2 of 19 be filed within 2 weeks.
Like,
IA 1 of delay of 2 days in filing the appeal is condoned. IA is allowed, appeal is admitted for hearing record.
This case, I appeal for respondent, madam.
I am for the appellant, my lord.
27 I appear for the petitioner's appellant's counsel.
What is the matter?
The matter relates to disqualification of a member of town panchayat on the alleged ground of violation of the whip. Matter is urgent because no interim order was made, hoping that the matter will be disposed of.
Oh, 21, this is pending since 21. And even 22 is now coming to an end. So
Yes,
it will go in the next year, January.
no, it lies in a very short.
When you appear, does it lie in a narrow compass? You will take 2.5 hours.
No, I'll just take 10 minutes. It is covered by judgment. If I may say so with respect, it is covered by a adjournment ruling of this order.
Did you assure us that not less than 5 minutes? Then we will take up.
Very well, very well.
Otherwise, we don't have.
I'll finish in 5 minutes. May I?
Not admitted. Oh, appeal is not admitted as yet. Appeal is admitted for hearing. Heard on IA1 of taking into account nature of controversy. December date some, Mr. Learned senior counsel for the appellant submits that the controversy involved in this appeal is no longer res integra and is covered by a judgment of this court. In view of opposite submission, let the appeal be listed for final hearing. He also assures this court that he shall not take more than 5 minutes in concluding his submissions. In view of opposite submissions list and taking into account the nature of controversy involved in the appeal, IA is allowed. Let the appeal be listed for final hearing on which date? 12th December 2022.
please.
12th December.
Obliged.
Admission number 28, government advocate.
Yes. I tell you when we should tell them. What now? Here go. Why you are appearing in this case, Mr. Aho? Land reform. How you are appearing? Okay. Right, let him come. Password. He is admitted for hearing the issue notice record. Dissolution of marriage. What happened? Heard on IA1 of 20 in the meanwhile. You will not suffer from any viral fever if you argue us, right? There's nothing for senior to do in this case. No inconvenience. You should tell us what is the matter. As they admitted issue notice record heard on IA1 of 20 in the meanwhile. It is directed that operation in effect of impugned judgment insofar as it directs dissolution of marriage shall remain state. But you will not mend your ways, right? Whatever we may do, but you will not correct yourself. You will not make it a point to, how do clients engage you? They should see your performance and thank their stars for engaging counsels like you. Really, I mean, I'm surprised. You don't even understand the order which is dictated. You are dependent on her. She explains, then you understand. You have not done law. Night college, something, evening college. Then how many years? Don't understand English. Then we have dictated the order in your presence. You don't understand what is it. Madam, tell her the stay has also been granted. He doesn't know. And he has to pay process fee. He will not know.
We have agreed on the terms of settlement. May I request for a passover, please, to just.
All right. Yes. Huh? Yes.
On the last occasion, your lordship had asked me if I had filed objection before the Karnataka Medical Council, my lord. In lieu of these two, of the order of this honorable court, my lord, we have not filed the objections before the.
You file objections, we will direct medical council to decide.
If your lordship can find these citations, one which is.
My lord, in serial number 31, I am appearing for respond Buron, my lord. Serial number 31, my lord.
Followed by your own lordship's order, my lords. Which
Oh.
can- which can-
Yeah.
The possible-
He's appearing. He's appearing. Ah, yes, what do you say? Covered by decision.
My lord, I am appearing for respond Buron, my lord. I have just issued notice, my lord. The learned single judge has directed
Then
to.
you just issue means you cannot issue any notice to anyone like this, just issue. You should have the, Mr. The.
Basing on the complaint,
Okay, position.
my lord, my submission is that basing on the complaint, I have issued notice. I have not yet registered the case. The procedure is that first we will get the explanation, and if the KMC does not find the prima facie case at
No,
face
no.
value itself.
Fine, that's it.
Only if there is a prima facie case, then
No, no,
everything
you
will start, my lord.
Even if there is a prima facie case, you cannot proceed against a hospital.
My lord, under Karnataka Medical Registration Act.
For same parties, you have already suffered an order. This thing, 28th January 2015, WP number, fine. In this, mark the presence. This read petition. No, this intra-court appeal has been filed against an order dated 10th of December 2020, passed by Lawrence Single Judge in WP 41246/2015, by which writ petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of the appeal briefly stated are that Karnataka Medical Council issued a notice to the appellant, which is a hospital, full stop. The appellant challenged the validity of the aforesaid notice in a writ petition, which was disposed of by an order dated 10th of December 2020, passed by learned single judge. Paragraph. Learned counsel for the appellant submitted that the controversy involved in this writ petition in this appeal is no longer a res integra and is covered by judgments of this court dated 28th January 2015 and orders dated 28th January 2015 and 14th June 2019, passed in the case of appellant itself. Paragraph. In view of the aforesaid fact has not been disputed by learned counsel for respond number 3. Paragraph. For the aforementioned reasons in the judgment dated 28th of January, aforementioned orders dated so and so, the impugned notice dated 15/9/2015, right? In the beginning itself, it could come 15/9 date also 15/9/2015. Insofar as it pertains to the appellant is hereby quashed. If the result, quashed, the order passed by the learned single judge is set aside. Order passed by learned single judge is set aside, and then this, for reasons in the order dated so and so, judgment is order set aside, and then notice is quashed. In line below, in the result, appeal is allowed.
But
In 97 days, we will condone the delay. Third on IA one of the delay condone, right? 197 days, 194 days. Let the appeal be listed for orders on admission.
He is not there today.
So what should we do? It will be put up.
Actually, we haven't gone through. Just want to keep going.
Applications for grant of occupancy rights.
Claim. Talent at failure. Claim will, and maybe misfavor. If you are review single judge, don't interfere with the order, single judge. But in case if you respond and produce certain material to show that there is a claim made by him, because if what was passed on account that there is no claim in form. If there is any material to show that there is a claim made by him, then the same may be before the single judge advance any material so that he has not displayed. We'll ask him. We'll ask him.
Yes.
What is the material to show that you have made a claim in respect of this property? No. All those things cannot be looked into because when the order was passed in a review petition, the learned single judge while passing on order in the review, he has made it clear. If you show something to establish that you have made a claim in respect of that property, then the single judge can consider. You have to show us where is the claim. Page number? Yes. Or number 7. Yes, which is the survey number in disputes? Then? When was the spot inspection? When was it? No claim within the prescribed time. You have to make a claim unless you show that there is a claim. There is already this court has quashed the occupancy right granted in your favor. In the review petition, that order has been upheld. But with an observation that if you show before the single judge that you have made a claim in respect of that land, where is that? Annexure, there is no claim. Survey number, that survey number is not there. The order passed by the single judge quashing your order is not set aside. That will remain then. How can he? How? Because in the review order, it is made very clear, unless you establish that there is a claim made by you, the order passed earlier will stay. That will survive. What is that to find out? You have to show where is the claim.
No. The moment the question is put, say next week, right? Nothing. Fine. Thank you. So next week. Next week never comes. No, nothing.
That is the only dispute, Mr. You have to show us.
He would have taken half an hour to argue, would not have made the point. We have done the homework and we have put the question. You should be able to answer. You did not say that you are not ready. Nothing.
You cannot produce it. It has to be there. Because in the order passed by the review, the learned single judge had made it clear. In case you produce any material before the single judge in the writ petition, then you have not produced anything. Unless without that, this order could not have been
2
passed.
days, nothing happens in 2 days. Do not create the record. Fine. Next. No, you should have found out. Thank you.
Second DS, government advocate.
Yes. Issue notice of IA 1 of 21 and 2 of 21. Yes, what is it? Why did you not claim the salary at the enhanced rate during the period when you served? Number one, what is the provision of law or government order saying that a teacher of a private unaided educational institution is entitled to salary at par with teacher of a government school? Nothing is concerned. Tell us the provision. We will allow the appeal right away. And why did you not claim during your lifetime? I mean, while you were serving. Sorry.
He made a claim to the institution. They rejected it.
Para 8, read para 8. It's simple, right?
Yes.
And if you have some provision, go to before single judge. You did not demonstrate before the single bench. If you have, go file review. If you have any. Not there, fine. Heard on. Heard on IA 2 of 2021, an application seeking condonation delay of 66 days in filing the appeal. After hearing learned counsel for the applicant, delay in filing parties, delay in filing, the appeal is condoned, IA is allowed. Heard on the question of admission. In this intra-court appeal, the appellant has assailed the validity of the order dated 2nd of December 2020 passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant was appointed as a lecturer in biochemistry in Alva's Education Foundation. Appointed as lecturer in biochemistry on 9/5/1997 on consolidated salary. Full stop. The appellant thereafter was appointed as full-time lecturer on 9/11/1997 in the pay scale of 2050-75-3950 per month on a probation for a period of 1 year. Full stop. The appellant worked in the institution, namely whatever, for a period of 7 years and 20 days. The appellant thereafter resigned from these services on 2/8/2004 and his resignation was accepted on 8/11/2004. The appellant was relieved on 3/11/2004, 30th/11/2004. Paragraph. The appellant thereafter issued a notice on 4/5/2005 by which a sum of rupees 13,31,937 was claimed on account of arrears of salary between the period from 11/11/97 to 30th/11/2004. Full stop. The respondent number, the institution denied the claim. You would say herein after referred to as the institution. The institution denied the claim of the appellant. The appellant thereupon approached the Karnataka, approached the revisional authority approach appellate authority under the Karnataka Education Act 19 revisional authority. The revisional authority under the Karnataka Education Act, who by an order dated 26/8/2006 rejected the petition. The appellant challenged the said order in a writ petition, namely WP number 17204/2006, which was disposed of by an order dated 30th/11/2006 with the direction to reconsider the dispute and to pass appropriate orders. Paragraph. The institution against the order passed by the learned single judge institution filed a writ appeal, namely WA number 16377/2011. The division bench of this court, while disposing of the writ appeal, directed the revisional authority to dispose of the matter based on the material available on record without being influenced by the order of learned single judge. Full stop. The revisional authority by an order dated 8/2/2016 passed the order, which was again assailed in a writ petition by the appellant, learned single judge by order dated so and so. 11 order dated 2nd December 2020 has dismissed the writ petition in the aforesaid factual background. This appeal has been filed. Learned counsel for the appellant submitted that the learned single judge.
How many rounds of litigation stamina?
So learned counsel for the appellant submitted that the learned single judge grossly erred in not in dismissing the writ petition. On the other hand, learned counsel for respondent has supported the order passed by the learned single judge. Paragraph. We have considered the submissions made on both sides and have perused the record. Full stop. It is full stop. The claim of the appellant for arrears of salary to the extent of rupees 13,31,937 is for a period from 11/11/1997 to 30th/11/2004 is based on the ground that he is entitled to salary and allowances at par with the teachers employed in government school. However, it is pertinent to note that the appellant did not claim the aforesaid amount for a period of 7 years and 2 months while he was in service. Full stop. After the petitioner resigned, after the appellant resigned from the tendered his resignation, in the year 2005, he staked the claim. Full stop. Besides that, neither any provision of law nor any government order was brought to the notice of either the learned single judge or to this court, which entitles the appellant to claim salary and allowances at par with their the teachers in government school. Full stop. Paragraph. For the aforementioned reasons, we do not find any merit in this appeal. The same fails and is hereby dismissed.
In this matter, my lords, I am appealing the appellant. Lordship may kindly have it tomorrow, my lords. Just 1 day's accommodation.
He says that it does not survive.
Then it might be recorded, my lords. If he says that the payments have been done.
Learned counsel for respondent has filed learned counsel for respondent number 1 has filed a memo stating that the entire amount of dues have been paid to the appellants. Full stop. The aforesaid memo is taken on record. In view of aforesaid submission, nothing survives for adjudication in this appeal. The same is disposed of.
Much obliged.
Read and be not dependent on them. You can move because they would have these counsels there.
Yes. What is it? Review. Joint submission.
Similar matter. But notice appeal number 541/21.
Issue notice rate list along with WA number
541/2021.
Rajeshwara PN.
Huh?
Contention raised by the petitioner.
Send to lordship. Yes, sir. Yes.
Petitioner, apparent is the petitioner.
So you are less meritorious, right?
We have produced my lord, respondent number one. She is not at all, my lord, belonging to the state village, my lord. She is married and she has gone to.
No, are you not less meritorious?
Venkipura village, and she has taken the widow pension, my lord, on that village. My lord created my lord voter list of the said village of Chiratalu, Algoteri village, and claimed that post money. That has not been my lord considered by the single judge. Single judge only to the said that merited.
Not considered.
Lesser than merited. Application itself of the
Did not appear. File review if you want anything. What to do is not considered means it can't be considered in writ appeal for the first time. You will not appear before learned single judge then, and then argue this considered, not considered as it is. But you should advise them properly, right? File a review. That's your appropriate remedy. We can't do anything. Choice is yours, sir.
I will left this appeal pending. I will file.
Law does not permit. Law does not permit you to prosecute two remedies simultaneously. Choose. Or we will decide it. What's the problem? Decide you argue what is.
I am permitted to fill the review petition.
After arguing the matter to some extent, learned counsel for the petitioner, appellant seeks leave of this court to withdraw the appeal with the liberty to file an application seeking review of the order dated 9th of December 2020, passed by learned single judge. In view of aforesaid submission, the appeal is disposed of in terms of liberty as per. Yes. What can be done? Read section 7(7) of Payment of Gratuity Act. That's why Mr. Naik is smiling. Nothing can be done more. So let him deposit. So how much time?
4 weeks.
Why 4 weeks? You have lost in repetition in this thing now. 7, 6. You don't have money. Huh? No, you don't have money, then don't contest the litigation. There's no point. Nothing can be done. No money. Person who has no money is the happiest one. We don't know. There's nothing wrong with the order. We can interfere with the same only if you are ready to deposit. Deposit it within 3 weeks. This intra-court appeal has been filed against an order dated 7th of June 2021, passed by learned single judge, by which
by which writ petition preferred by the appellant has been dismissed, and the order dismissing the appeal preferred by the appellate authority under the Payment of Gratuity Act 1972 has been upheld. Paragraph facts giving rise to filing of this appeal briefly stated are that being agreed by an order passed by the controlling authority under the Payment of Gratuity Act 1972, the appellant filed an appeal before the appellate authority. However, the appellant did not deposit the amount as required by Section 7 within bracket 7 of the Act of the Payment of Gratuity Act. The appellate authority, therefore, by an order dated 30th/9/2019, dismissed the appeal. The appellant challenged the aforesaid order in a writ petition, which has been dismissed by the learned single judge by an order dated 7/6/2021. Paragraph. Learned counsel for the appellant submits that the appellant is ready and willing to tender the entire amount as mandated under Section 7(7) of the Act before the appellate authority within a period of 3 weeks from the date of receipt of copy of the order. Full stop. Learned counsel for respondent fairly submits that he has no objection to restoration of the appeal. Paragraph. In view of aforesaid submissions and in the facts of the case, it is directed that in case the appellant tenders the entire amount as required under Section 7(7) of the Act within a period of 3 weeks from the date of receipt of copy of the order, comma, the appeal preferred by the appellant under Section 7 of the Act shall be heard on merits. Accordingly, shall be heard on merits expeditiously. Line below. According to the appeal is yes. Ratio is not yes. No. No. So you or you are in action, how he can be held liable to pay interest?
He has made an application. STM is there. Left open and it is demanded for them to do something.
Yes. So this is reconsider the liability of the petitioner, right? Page 17. Huh? Read paragraph 5. What's wrong?
I take contentment with the learning counsel for the petitioner. That's the undisputed fact that no part of the petitioner, the BDA did not take necessary steps to renew the lease despite the petitioner having submitted a representation as long as on 25/8/2014. The liability to pay interest from 25/8/2014 onwards cannot be taxed. As demanded in the impugned order. Insofar as the demand for a payment of the other amount except the lease to any of the taxes that were imposed has also been set aside without the central government and the state government being party to the proceeding. But
what about
the GST, central GST and state GST?
Read this page 14. It is the grievance of the petitioner.
Date of expiry. BDA did not take any steps in this regard. The interest for the period from 2015 to 2016 in the issuance connected.
What's wrong with this? How can you claim interest for this period? You did not decide, you kept it pending for 4 years. You are now demanding interest. How? You are meant for people, right? Huh? Or you have come into existence to torture them. Whosoever makes an application for allotment should be dragged into litigation up to Supreme Court and he should die. Is that the idea? No, you should have a pro-public, like you don't have any distinction to who decides all these appeals are filed and this. Yesterday, Friday also we learned this thing in a frivolous matter. Are you meant for people or you are just to see that they are harassed? What? No, I mean the approach should be pro people, right? Why should you not tell them that there's no point in filing the appeal? First of all, he should not have been dragged here to the High Court. Then again, if he has succeeded and matter has been remitted for reconsideration, again you are in appeal. What's wrong? Nothing. Don't see anything. Minister, but so far we have restrained ourselves from imposing. Now it's time that we should start imposing costs on you. And this is the recent past. This is the third case we have come across. All very. You ask your colleagues who appear for BD. Last week only we have some accountability, Mr. Somewhere like it's a public money. We don't see any reason to interfere. Tell us why. Why should he pay interest for a period for which you have not decided his claim? Tell us. Then whatever he has for a period for representation 25/8 till 11/9/2018. That's what the learned single judge held is not liable. Correctly.
Applicable taxes are also set.
Please step two.
This
Even interest to the court also is step two.
three.
Everything is step two.
3. What is C? Reconsider the liability paid amounts.
Except the lease amount, everything is step two.
3 months. By now you should have decided. You should have been in a writ petition. Instead you are. You should have chased him to second round of litigation, right? By simply passing an order, pay 50 lakhs or 1 crore, 14 lakhs, pay something like that. You should have said, he would have come running here, said that, sir, I am not liable to pay this. What basis they have calculated? You can say anything and do anything. You are an authority. You could have demanded 3 crores from him. So he would have come saying that I have, sir, where from they have computed the figure of 3 crores. I don't know. I'm not liable. Take this. It's intra-court appeal. Heard on IA 1 of 2021 an application seeking dispensation. 2 of 22 allowed. Appeal appears to have been filed within limitation. This intra-court appeal has been filed against an order dated 16th of December 2020 passed by the single judge, by which a writ petition preferred by the respondent has been disposed of and the matter is remitted to the Bangalore Development Authority, herein after referred to as the authority, to reconsider the liability of the respondent to pay the amounts, except the lease amount in accordance with law and in the light of observations within a period of 3 months. Paragraph facts giving rise to filing of this appeal briefly stated are that the respondent was allotted a civic amenity site and the lease granted to the respondent was due to expire on 25/2/2014. The respondent made an application on 25/8/2014 seeking renewal of the lease. Full stop. The aforesaid application was kept pending and eventually by a communication dated 11/9/2018, the respondent was informed that the lease has been renewed for a period of 30 years from 23rd of February 2014 to 22nd February 44, subject to the respondent making payment of the amount. Full stop. The respondent was also asked to pay interest for a period from 25/8/2014 till 11/9/2018, and as well as GST and service tax. Full stop. The respondent assailed the aforesaid demands in a writ petition which has been disposed of by learned single judge. Learned counsel for the appellant submitted paragraph. Learned counsel for the appellant submitted that the appellant could not that learned single judge grossly erred in quashing the impugned demand notices and erred in directing the authority to reconsider the liability of the respondent to repay the amounts. Paragraph. We have considered the submission made by learned counsel for the appellant and have perused the record. Full stop. The respondent had made an application seeking renewal of the lease on 25/8/2014. The aforesaid application was kept pending for a period of 4 years, and the authority by an order dated 11/9/2018 directed renewal of the lease. Full stop. The respondent obviously could not have been held liable to pay interest for the period for which the appellant for inaction of the appellant and in respect of the period for which the appellant did not take an action to decide the application. Full stop. From the operative portion of the order, we find that learned single judge has remitted the matter to the authority to reconsider the liability of the respondent to pay the amounts except the lease amount in accordance with law and in the light of observations made in the order within a period of 3 months. Full stop. The aforesaid order is just and proper in the facts and circumstances of the case and does not warrant any interference by this court in exercise of powers under Section 4 of powers under Section 4 of Karnataka High Court. Paragraph. In the result, do not. In this intra-court appeal, you simply say does not call for any interference in this intra-court appeal. For the aforementioned reasons, do not find any merit. Fails and is hereby. Previous corpus. What? Learned counsel for the petitioners undertake to correct the cost battle during the course of the day. Learned SPP. What SPP? Praise warrant is granted a week's time to enable her to file status report. I do it just now. Appeal is admitted for hearing. Each notice office is directed to secure the record of the family court heard on IA 1 of 22. Does not sufficient. Orders are required to be passed on IA 1 of 2022 as the petition under Section 13 of the Hindu Marriage Act has been dismissed. Accordingly, IA 1 of 22 is disposed. Why do you file application such frivolous? We should impose cost on you. Why apologize? Don't find anything for which you have to seek an apology from the court. Good. Yes.
What are the include is passed with the government? interesting the inquiry under Rule 14A of CH-2. Covered judgment not covered by judgment coordinate.
What?
Difficulties without. It is a reading motion.
What objection? Is it not covered? You should have that much of fairness, Mr. That's like Mr. Lakshmi Narayan. You should have that much of, if it's covered. There's no point in seeking adjournment and trying the objection is ready. What he has made a statement. What do you say? Covered? You don't know. What to do? I will take it up day after.
Please.
Learned counsel for the petitioner submits. Where are the citations?
One more petition, Lord. 17548.
Who will tell us what are those judgment citations? Give it. Learned counsel for the petitioner submits that the petitioner is an executive engineer in Karnataka Rural Infrastructure Development Limited. It is further submitted that that an order under Rule 14, capital A of the Karnataka Civil Services Classification, Control and Appeal Rules dated 27/7/2022 cannot be passed as the board is the competent authority to take an action on the inquiry report. Full stop. It is also submitted that the aforesaid issue is no longer res integra and is covered by 2 division bench decision of this court in so and so versus so and so. Hey, Mr. Unless he gives, you keep the order sheet, don't mistake. We will not sign it. So and so versus so and so. This on 23rd November 24th November.
Under matter, number 17548 for 2022.
We don't know. No. So, I mean, is it an occasion, get one case listed, buy one, get one free, something like that? We don't have that scheme, Mr. Please mention like this. All youngsters are watching you. They will learn from you that the buy one, get one scheme is in the vogue in Karnataka High Court. Get a case, move a memo, get another case listed. Mention it, whatever. Or say that it should be listed along with that. That is also, but if you link it, get it tagged, this case also will not be decided because he will seek for time in another case and both will be hanging fire. So advisable is to go at one case at a time, right? Because he is ready to seek adjournment, right? Ask him. Interim order, if any, shall continue till next date of hearing.
Number 44.
Huh? No. Hold on, IA1 of 2020. What? It is substantially covered or we don't. Yes.
That is in my case.
Your case. There is not Kalburgi bench. You keep it there. Just you keep it there in that file. Why we are taking up another case? Why should you give it to us? We thought he is giving us a compilation saying covered. What's it? Heard on IA1 of 2022 for the reasons assigned in the application. What dispensation? A requirement of filing the translated version of annexure. Certified copy of annexure rail is dispensed with in the result IA1 of 2022 is allowed. Third on the question of admission. Notice on behalf of 1 and 2. 1 is accepted by learned additional government advocate. issue Mr. Karnataka Examination Authority, Mr. Ramesh. Mr. N.K. Ramesh, learned counsel accepts notice on behalf of, you supply him a copy. Accepts notice on behalf of respondent number 2. Office is directed to reflect his name as counsel for respondent number 2. Issue notice to 3 and 4. 3 to 5. We don't know. But on IE. Third on IA1 of 2022, requirement of production of original copy of Annexure D is dismissed with. Yes, Mr. Notice on behalf of National Medical Commission, issue notice to respond number 1. Notice on behalf of Medical Examination Committee. What is it? Mr. Ramesh, you appear.
Third respond.
Yeah. The name is not shown. Yes. See, you appear. Notice on behalf of respondent number 2. Notice on behalf of respondent number 2 is accepted by Mr. Ramesh. N.K. Ramesh, office is directed to no, and notice on whereas notice on behalf of respondent number 3 is accepted by Mr. Lakshmi Narayan, learned government advocate. Office is directed to reflect their names. They pray for short accommodation to enable them to seek instructions when day after. Just on 23rd, supply 23rd.
Passover matter, 28. 828. First round was now.
File recall. And for the appellant, even when the matter is called in second round, Mr. N.K. Ramesh, learned counsel for respondent number 6 to 16 and 18 to 2020, 18 to 22, 18 to 20. Awaiting the appearance of learned counsel for the appellant, hearing is deferred. List on 23rd November. We'll dismiss it. It doesn't appear on that. That let them mention, keep it aside.
I appear for the petitioner's lordship. Lordship, all the 3 are the government medical colleges, lordship. They are new medical colleges. MCA has found out certain lacunas and for giving the recognition. As on today, the final recognition has not yet, the inspection for final inspection has not yet happened. We are expecting them in the month of November, lordship.
So, you are, so what, madam?
Lordship, if the matter can be adjourned for short accommodation, lordship, then the entire matter can be disposed of because the MCA is, we have complied with all the directions of the MCA lordship, and in fact they have also approved, but because of the physical inspection, the matter is not yet considered by them, lordship.
Post it after 6 weeks. Learned counsel for the petitioner prays for adjournment on the ground that Medical Council of India is National Medical Council is likely to inspect the premises of the petitioner. List in view of proposal submission, list after 6 weeks.
Oblige, Lordship.
47.
Pending. Learned counsel for the parties jointly submit that the issue involved in this appeal is pending adjudication before the Supreme Court in WP number 1397 or 21. In view of proposal submission, hearing of the petition is deferred. 2020, instead of 21, it's 20, right? 20. In view of proposal submission, hearing of the petition is deferred till decision of the aforesaid writ petition. However, parties are granted the liberty to mention the matter as and when the writ petition is decided by Honorable the Supreme Court. Connected 48.
35 of
Okay.
1397 and 55.
WP number 1397 bar 2020 and 35 of 2022. Right? Not it. 1397 of
2020 and 35 of 22.
20. Forty-eight.
48. Conclusion.
Password. Password. It is there. Password. Why? Counsel. It's listed very early, right? How can a petition of the year 2022 be decided that very year? It should come up in 27, right? Which respondent? Ask him which respondent is appearing. You are appearing for. We don't know by ourselves, right? You stand in between. We don't know for you or which respondent you are appearing. There's nothing, no system which tells us automatically. You should tell us that I am appearing for respondent number 3. I want time to file objections. Understand it. Why is it so difficult? Not difficult, right? Seeking an adjournment is never difficult. Arguing a case is difficult. So how much time do you want? Yes, Mr. Lakshmi Narayan, correct? No? Yes, he agrees. Yes. What? How much time? Learned counsel for respondent number 3 place fund is granted 2 weeks time to enable him to file objections. Nothing survives actually. Nothing survives in this writ petition. We don't know why you are seeking time. Maybe if a counter is filed and that petition is decided different scale. If nothing survives, right? The seat matrix of 2021 by this, Mr. Lakshmi Narayan would have told us by now that nothing survives. No relief can be granted to the petitioner. Despite that, why are you seeking adjournment? No seat matrix of Mr. Seat matrix of what? Which year they have challenged? Which year? 21. When the academic session has commenced? Tell us. Huh? Over, no? So what relief can be if can we quash it now? Huh? Can be done. No. What happens to just a minute? No, seat matrix was notified. Was it not? People have got admitted, like they've taken admission to course. You are saying that we can quash it. So even the admission of those who are not before us can be quashed. Let it. Huh? No, good to know that we can do wonders also in 226. Good to know you said that it can be quashed. Fine. We thought that probably you would tell us nothing survives now. Okay. Not comfortable in jail. Not comfortable in jail. Good. Your friend has argued you have not been able to get through. That's the uneasiness, right? Pressure is more that see how he has done it. You are not able to get an audience from the court. Huh? That's it. Huh? No, we'll take it as just now. Let this evidence thing be over. We'll sit down. 10 minutes we'll take. What? Want to withdraw? Withdraw. Oh, that's why you are smiling, right? You have won him over. Huh? Is your employee? Then what did you do?
Husband and wife.
Oh, husband, wife. Oh, that's right. You are for the husband. Wife. 49. Yeah, 49. 49.1. Learned counsel for the appellant seeks leave of the court to withdraw the appeal on the ground that the matter has been amicably resolved. Huh? Huh? Also, it has been amicably resolved, right? The dispute between the parties has been amicably resolved. Not simply wants to. Okay. 49.1. Learned counsel for the appellant has filed a memo seeking leave of seeks leave of this court. Seeks leave of this court to withdraw the appeal. The aforesaid appeal is dismissed as withdrawn. We then say 49. In view of dismissal of MFA number 162614/2014, we are not inclined to proceed further with this contempt petition. The proceeding is accordingly dropped. You don't want to withdraw 49.1. Both. Oh. Dismissal, we are not inclined to proceed. Same is dismissed as we are not inclined to proceed. The same is accordingly dropped. In the result, petition is dismissed.
So
What record this? No, put the flags, mister, not like this. Put the flags, proper flags. Order under section 28.1, 28.3. When what is the order 28.3? Their objections have been dealt with. Flag, right there. Memo taking possession, everything you should flag, right? Don't give us. Yeah, understand. Yes, madam, please see to it. Notice under 28.1, the 28.3 orders deciding the objections under 28.3. Then when is this thing? Final notification issued 28.4. Then what is this thing? When the possession taken, when it is handed over to the board, everything you should give. Different notifications, like how many different notification, which 3 different notification, what is the extent of land? Even if you give it by hand writing, that will do. But you take the assistance of that person and give it to us. If supposing 3 notifications have been issued, write down these 3. And what is the extent of land, right? Write down and give it to us, right? So then item number 50, learned additional government advocate has that in compliance of the order, mark everybody's presence in compliance of the order passed by us, learned additional government advocate has produced the record for perusal, reserved for judgment, delivery of.
What said to have been not pursuant to the minister's letter.
Hey, we don't know this. It's all argument is over.
Yes, sir. I am not
Fine.
arguing with that.
Yes.
Well,
Yes.
Finally, for 51, the Farah Fatima.
Yes, sir. 1 minute is EPS corpus. Same person. No. 1 minute. EPS corpus we are taking. See his predicament, madam. He's so uncomfortable inside the jail. You keep people in jail without trial. Is how many months? 9 months. See? Hey, madam, see, that's what we were telling SPP on 16/11 also he sought adjournment. We posted it on 21st. Well, this is Article 21 is involved, madam. Don't this thing. Take it to this thing. Casually. He is in jail for 9 months without any trial. What is the ground? Kannada annexure not supplied. See, how did we guess? So that is judgment of Supreme Court, right? If you are in custody, then also you can be, an order of detention can be passed. What did you do? What were you doing? How many cases registered? 19. What are you doing? Huh? What have you done? Repeated offenses? Oh, hardened criminal, right? So tomorrow, madam, no adjournment. It will continue in the list. You can mention tomorrow. No, please ask him. Don't this not. We have again at his instance we have adjourned. If he has some difficulty, then ask the government to make some other arrangement. Yeah, you don't. Yes.
51, Farah Fatima. The Gopal ke Bilal ne.
You are arguing something, right? No? Then who are you? There is no proxy counsel. Advocates Act, there is nothing proxy. Advocates Act only advocates and senior advocates. So either you are a senior advocate or you are an advocate. Hey, we don't know. We don't instruct anybody to argue or not to instruct anybody to seek adjournment. We don't instruct either ways. We are concerned with the case which is listed before us. What is it? What is it? It's not tomorrow. What is the case about? What has the learned single judge done? See, Mr. 4/4/2022, none appears. All after summer vacation. Now you intend to see that call after winter vacation in New Year. Huh? How long he will suffer, right? Huh? What? Why not today? What we will do today? Huh? Not keeping well? Cost of rupees 5,000. You are agreed by imposition of cost. Tomorrow it will be dismissed, Mr. Don't come. Don't come tomorrow. If you want to appear, then be ready. Otherwise, don't come to this court and seek another this thing, right? Tomorrow. And no adjournment on any ground, Mr. Right? Tomorrow. You be ready. You have got 24 hours. Get ready. Prepare the case. This is also court hall, madam. This is also court hall. And it is, we think that it is entitled to priority. Tell us what is it. No. No. Finally means it is listed for final hearing. So no question of final or interlocutory chance. Yes. Tomorrow. Get ready. Same advice what we told the gentleman, the young boy before you, don't come. This is not a good court for the juniors who seek adjournment. We are ready to encourage you provided you argue, not to seek adjournment. And especially in cases which are 10 years old. You want right, this it should be adjourned for beyond winter vacation, 23 years. So in 2023, 10 years it should complete, then only it can be called for hearing, right? Otherwise, the court is not justified in insisting that it should be argued, right? That's the idea. So don't come tomorrow, we will dismiss it.
May I make a mention?
Come ready, otherwise don't. The object of telling you is don't come tomorrow for seeking an adjournment. We are telling you in no uncertain terms that it will not be adjourned on any ground. So don't, you send somebody else, don't appear. We will deal with him or her also. No adjournment.
May I make a one mention, please? I appear for the respondent in this case.
Tomorrow?
Instead of tomorrow, day after tomorrow, part
No.
matter is there before Dharwad.
We will see what is there. We will see,
Please.
Mr. Jeffrey. Don't worry.
Please, Mr.
Supposing if we adjourn day after, every case we have to adjourn. That's the predicament of a judge. Probably.
Hey, no, for my personal inconvenience, because I have to give over the division bench of Dharwad.
We will accommodate you.
Please,
Don't worry.
please,
If you are unable to appear, we will see what is to be done.
Please,
Mr.
please.
Tom.
Please, Lord.
You can appear simultaneously before Dharwad bench and this.
Please.
Here in this case, you will argue only for 5 minutes, right?
Yes,
You
obviously.
can appear. See, 5 minutes you will argue and then appear before Dharwad bench.
Please,
Yes.
Lord.
Yes.
Because I am physically going before the Dharwad bench. Therefore,
From there you appear.
Please,
The
Lord,
Seva
I'll
Pit
appear.
is there, no Dharwad bench also.
Please, Lord.
Yes. Yes.
Bacha.
Yes, what the? Where is the? Show his name. We'll take it up today. Let the other council come. We will take it up today. Yes. You call his case again. Huh? He's been-
But if I
Oh, really? What is the case? What you have been doing for 8 years now? So therefore, it should be posted after another 1 year. Huh? What is the date? Tell us. Oh, it was that 23/11/21. So this direction was issued 1 year ago. 16/11. Ah. So it's we are 22, right? In 22. What is the explanation for? What date? You tell us. You are seeking time. That's why we are asking. 29th. Learned Counsel, 29th. Learned Counsel for respond number 4. Grace warrant is granted. A week's time to enable him to produce the record in compliance of the order dated 16/11/21. It is made clear that in case records as directed by the aforesaid order are not produced, adverse inference shall be drawn. List on 29th November 21. Not 22. No, what have you list on 28th, 29th November 92. 22, not 92. He is making us go decades behind. Yes. Oh, good. Memo. Yes. It's in this field, parties along with their counsel present. This appeal under section 19 within bracket 1 of the Family Courts Act 1984 has been filed against judgment and decree dated 28th of February 2015 passed by the family court, by which petition filed by the husband under has been partly allowed, and the marriage between the parties has been dissolved by a decree of divorce on the ground of cruelty. Paragraph. During the pendency of the appeal, learned counsel for the parties jointly submit that during the pendency of the appeal, the parties have amicably resolved the differences between themselves Learned counsel for the parties have also invited the attention of this court to the application filed by the parties under Order 23, Rule 3 of the Code of Civil Procedure. Full stop. The terms of and conditions of the compromise arrived at between the parties read as under. Paragraph 3 to 9. Paragraph 3 to 9. Paragraph. The in view of compromise arrived at between the parties, the judgment and decree passed by the family court is modified to the extent mentioned above. Accordingly, the extent mentioned above and marriage between the parties is dissolved by a decree of divorce. Marriage between the parties is dissolved by decree of divorce and the judgment and decree passed by modified judgment and decree is modified in terms of compromise arrived at between the parties. Line below. Accordingly, appeal is disposed of. So before that, after putting the appellant has acknowledges the receipt of a sum of rupees 1,75,000 by way of a check dated DD demand draft dated 29/10/2020. Then you write that dissolved and then modified and the appeal is disposed. Get their signatures.
Since it's report, whatever is there, I will prosecute in there in the file. There they are prosecuting matter. They are taking the attack.
It says advocate has undergone heart surgery, he says. No, do you dispute that submission?
We have said that you should file it within a week, failing which adverse inference shall be drawn.
The connected matter, you are appearing for the very same party. He is appearing for the very same party in the connected matter. What will be
Tell him.
We'll adjourn by a week, but on the assurance by you by the next date the party has to file, because you are appearing for the very same party in the connected matter. By the next date you have to file it. We'll list it next week. He says he's
Also, I have stated that I will never be able to do whatever you want to do. I will there. This is recorded.
that we'll consider next week.
Learned counsel for respondent submits that the outgoing counsel
Counsel appearing in such matter.
Suresh P is unwell and has undergone a surgery. In view of aforesaid submission, hearing is deferred. List on 30th November 2022. It is made clear that in case statement of assets and liabilities is not filed on the next date of hearing, suitable order shall be passed. So take this. So list on Wednesday. Thereafter, suitable order shall be passed. List on 30th November.
A. Narendra, A. Krishna Password. 59. H. Reddy. Our
Your Lordship, is it serial number 60? 60? Lordship, is it serial number 60? 60?
that is passed over, sir.
Not PIL. Yes. Which case? Okay. Praise for the counsel for the appellant, praise for adjournment to enable him to prepare the case and argue the same. List on 24th November. You have given a synopsis, right?
Lordship, serial number 60. I may permit return from the case, Lord. 60.
It is passed over.
I filed a memo of retirement.
Mention it when it is called up.
Anything? Say anything.
The certificate to the password. Urban, the Vasan Kumar HC. Password matters. For 53,
Where is he gone?
There is the
Call it. Counsel. Display board. Despite that, he is not coming. Yeah. No, when the case is called in second round, then only you give NOC, right? Till then, you are waiting. Hey, we don't know. This all tactics we will not permit. You don't appear. Nobody is asking you to appear. Don't appear. We don't know. it will not. We will not adjourn the hearing, Mr. Understand? We will not adjourn the hearing. But the ability, right?
Please, desertion.
Desertion. Desertion.
That pleading is triggered reality. And how to sentence where he has said that he has left and so on. So that
We treated one cruelty.
he has not resolved the release at all on that. Before the trial court is, after leaving her, he has married his son with daughter. 5 years before the plea. About any children from this marriage?
No issues, Your Honor.
No issues.
No issues. What application for the last 3 decades?
You are remarried.
No, Your Honor, I am not remarried.
What is photos at exhibit P10, P11? Exhibit P10, P11 photos with another lady.
This lady is my relative. He is also a central government employee like me. He is my relative. I have been moving with her to assist her for a personal work, for which the respondent has taking photographs of her, producing before this normal court, citing that I have got intimacy with her. That is allegation that has been cited in the records. Your Honor. The respondent has filed a case, exclusive case under section 494 in 9th edition SCM code, which has been acquitted. Even appeal preferred, criminal appeal preferred of this case has also been dismissed, Your Honor, by the competent court. That's a position. Acquittal orders also having in the kind of court, I can submit.
Your pre-judgment exhibit are. It is finding is recorded. Thing second by. It's 13.
You have earlier filed a petition for judicial separation.
Yes, ma'am.
That there is a finding that you are staying with another lady.
Only it has been cited. Parties just filed the case of beginning under section 494 90 of the SCM code. Only been observed, that's all. You.
He said there is sufficient. So, with that other lady, in a scooter and dashed against her. The prosecutor is basic criminal. That's a finding, mister, that you are living with.
There may be finding, Your Honor.
It may be finding means it is binding on you. You cannot say there may be finding. That is binding on you.
Finding, has to be very extensive about being-
Whatever it is, you have not questioned it. That is binding against you.
There only the finding.
It is a finding against you, mister. You had gone to the court. You have not admitted. You have not admitted. He has filed a statement. And that was contested before the family court.
When you contest before the.
And the family court has given a finding against you with regard to that.
Only
You cannot
finding
say
has
that.
been, but when allegation made by the respondent, taken note of it. We have a, Bharat, it has failed, it excludes the case of 494.
That may be.
That and it has been acquitted.
That does
time
not.
it was very prejudicial stated.
Oh.
That was a prejudicial state. In addition to this, it's very- it's- section 494. The all three for criminal cases against me. So this is right with the- all criminal cases against me.
When she
There
has
are
left.
no grounds to continue with this relationship.
And this petition is filed under what provision? This petition is filed under what provision now? Under what provision you are seeking divorce?
Yes. It's a petition number, it's a MFA filed. Reasons.
What reasons, on what ground you are seeking divorce?
Yes. First of all,
Sir, it is whether it is a ground of cruelty or whether it's ground of desertion.
both.
No,
Grounds of desertion,
you are not invoke cruelty. It is only under 13(1)(b). 1A is not filed.
I'm pretty sure I can submit my argument. Concisely for 10 days.
It has to be borne by records. Your petition is only under 13(1)(b).
That is true, Your Honor.
It's
That
only
is
then
true.
if it is true, then it is only under desertion.
Sir, because I have been moved from place to place on transfer, sir. That has been taken advantage by her, but she is continuing in the house. It is a prison by the family court that I haven't deserted. If I leave it her, it will be called in the domestic violence. If I don't keep away from her, keeping moving from place to place on transfer, it is not a difficult. What is the grounds for me just to continue my
Therefore, you don't dispute that she continued to stay in your house. Therefore, you don't dispute that she continued to stay in your house.
I'm not. Situation become new to me for me, you have 30 years.
Merely for that reason, you will not get a decree of divorce. That 30 years is over.
Also not able to leave. She was not able to leave. I am also not able to leave. The honorable courts have already granted me, sir. It's both from the high court as well as from the state court.
The petition is filed only on the ground of desertion. Show us in your pleadings where you have said that she has deserted you and on what date. There has to be a pleading, mister. There has to be a pleading. You have filed a petition only on the ground of desertion. Show us in your petition on what date she has left you, and for continuously for 2 years she has left you. Where have you said in your petition?
No, so there is there are cases. And we have filed so many mediation memos in the honorable court. The honorable judges and as well as the mediation centers are part of the reconciliation program. She stated that our target was only convict me. That is why she is not able to cope up with me. That means she does not want
Your
to join.
petition is only on the ground of desertion. If it is, that is true, means only you have to confine your argument only with regard to that. You have not filed a petition on the ground of cruelty, only on the ground of desertion. Ultimately, development, there has to be a pleading. Simply there is ultimate development, we cannot take cognizance of that. There has to be a pleading. Your pleading is only with regard to desertion. Show us from your petition, where have you said that he has deserted me on so and so date for a continuous period of 2 years? Show us. Show us from your pleading, Mr. Show us from your pleading.
I seen the order.
Not orders, from your petition, what you have filed in the court. If you have not said that in your petition, you will not get any relief. You have to show that as to on what date she has left your company and for what period she was not staying with you. That you mentioned in your. It has to be there in your petition, Mr. Where have you said it in your petition? Show that. For the last 2 years, 1 week you are saying that I am ready to argue, I am ready to argue. If you are ready to argue, you should have the papers also.
The petition and only the order copy and the appeal copy.
Every day evening you come and say that your matter is not being heard.
Nothing to be done. I have not filed any urgency. I have been against the dates of the son of the. I have not made any force.
Yes,
You
whatever
argue
you want
whatever
to say.
say, whatever you want to say. Whatever you want to say, please say, argue. Or do you want any assistance? We will appoint an amicus. Go ahead.
So I'm looking at the briefly the antecedents of this case. Then I'll come to the legal points. Concisely. My God, I'm 3 months. I'm appearing as the party in person. I'm appellate in this case. I married this respondent in the year 1990, 14 to 1990. When I was posted all India Radio Assam, I was in Silchar for about 2 years there. So I married her in 1990 when I took over to Assam. After I took taking over to Assam, she did not live with me by cooperating herself, citing the reasons, making allegations that she was not adjusted to that place and she wanted to take transfer to her native place. She is my faraway respondent. The respondent is my faraway relative. She is from Tamil Nadu. I am from Karnataka. From that time, she has been forcing me to take transfer to Tamil Nadu. For this, I did not oblige. It is because of the reason I wanted to come to Karnataka, Bengaluru, where my parents are residing. I am the only son to my parents who are all raised old that I have to look after her. She has not conceded to this, but to continue with it. She made adamant behavior and she insisted me that she wanted to go away from me and take shelter at her native place in Tamil Nadu. For which I have given my consent. After she went to Tamil Nadu, I got transferred from Assam to Orissa. I came to Assam from Assam to Orissa. From Assam, when I came to Orissa, I went to Tamil Nadu and took her back to Orissa. After taking her back to Orissa, there also she has been alleging that she was that atmosphere was not conducive to her, making allegations that the things are very filthy and the city was not clean, and she was making all petty allegations and making my life very much miserable. Once she demanded about 12,000 rupees to make payment to her brother for some job and I gave 12,000 rupees to her, for which she did not return. Then from there, my parents were writing to me to take transfer to Bengaluru and for which I am making representation to my employer. I am the employee of All India Radio and Desertion. So, conceding to my request, the employer has transferred me to Karnataka, not to Bengaluru. It is for Kolar Goldfields. So, when I went to Kolar Goldfields, on the way, the journey from Orissa to Bengaluru, the respondent making a lot of in my train and insisted me that she did not like transfer to Karnataka. She wanted to just take transfer to Tamil Nadu only. For this, again, I did not oblige. All the disturbances created by her, I lost all my belongings over the train. For my against which I made a complaint to the Railway Protection Police Force. After coming to Bengaluru, reporting to KGF, Kolar Goldfields, I started staying in my parents' house. That is my native place where my parents are there. And as I said, I am the only son to my parents. I had to stay there. After coming over to others, again she making Galata, she does not want to live in the locality. Because I belong to the community of the Potters. I belong to the community of Potters. There is a lot of filth and there's a lot of clay things there and all. If it's not rich, she would wanted to take transfer to Tamil Nadu. Again, she's making big Galata in my house. She did not serve properly food to my parents as well as to myself. I have been making up and down journey from Bengaluru to Kolar Goldfields. I've been we've been engaged in Kolar Goldfields for about 1 week on a departmental project work. Then again, she used whenever I used to come to Bengaluru to my welfare, she made allegations that she was not prepared to serve food to my parents. And moreover, when I demanded 12,000 rupees which I was paid, she said that is her money and she was not willing to pay. Then again, we are went to my neighbor's house, my office, and are making a lot of Galata that she wanted to transfer to take Tamil Nadu. She did not want to continue her. And she made allegation that myself and my parents were all harassing her. And because she did not oblige. Then they called her Panchayat for an various occasions from my community members. Plus, I called their parents from Tamil Nadu. They came and had a Panchayat in my house and us on several occasions. Even after that, she did not went herself. Because she has been encouraged and just to continue because she did not like that place. Then when I come there, she started inviting a danger to her life by dipping her finger in the energy immersion heater, as well as releasing the LPG gas from the kitchen and all. All these things apparently a lot of danger to my life and my parents. Then I sent again with serious terror to her parents to come over and advise her properly. Even after that, she did not mend herself. This is one phase of that. Then after that, she did not mend her and started inviting danger. And all the neighbors and community members are just alleging that I was not able to tolerate and I was not able to discharge my duties peacefully in the office, my lord. Then later, I finally said just to leave the house if she is not interested to leave with me. She did not go at all. She continued to be the adamant there. She continued to stay in my house. Therefore, I served a legal notice to her to take a degree of diversion just to go if she is not able to leave peacefully. Then, since she did not respond to my legal notice, I filed a case of judicial separation in 1996. After the case of judicial 1986, after receiving the summons, she found really enraged by receiving the summons that I had left with the family court and all. She spontaneously went to Mahila police station. She lost a case of 498A, section 498A for dowry prohibition that I have been myself and my family members for harassment for dowry. Then the police have arrested myself, my parents, my sisters, and all the family members are all arrested, and we are all enlarged and bailed. After we enlarged and then my parents, myself, and all, they were all just apparently danger to continue in the house. I left the house. My parents, my mother also left the house. So she came to took the complete possession of my house. Then we were myself and all were all doing my own things on transfer and all. She went to approach my employer in Madras. She submitted representation taking that I am harassing, that she has filed a case of dowry and all to get it transferred to Tamil Nadu. Seeking to her conceding to her demand, my employer transferred me to Neyveli, Tamil Nadu. Then I went to Madras and then I got a reverse the torture and the harassment and all. My father and mother died on the 1998 and 1991. When my mother died, she took the complete position of my house. I also went out of the house. That is the way I started leading the house. Then whenever I come to my house, just to taking some father works and legal things and all, she used to assault me and she did not permit my entry into the house. Taking the support of her henchmen, supporters and family members sent me out. She went to the police station to file a false complaint of assaults and all. Our police and all, they took the cognizance of her statement and started taking
consideration of remand, they started considering the complaint. They filed a plea for assault cases against me. Then I did not come to my house because apparently I left my house belonging to everything. I just stayed away from it for so many years. After so many years, 2 years, 1 year, 2 years, she developed a suspicion that I am developed some intimacy with another one. That is why I am not coming to you. She engaged on the group detective agency and took the photographs of myself along with where and all, just going with my office staff, artists, and all my colleagues and all. I'm submitting the police complaint that I'm doing with that and developing intimacy. Then she went to approach to the Hall of the Family Court. She filed a petition, the interim petition for seeking intention against Mary that I'm likely to marry a lady by Gangambika. On Gangambika, she has been alleging and alleged that I have constructed a betrothal ceremony. She has got betrothal. Accordingly, the intention has been granted by the Honorable Family Court that I have restrained from undergoing the second marriage. Okay, that is fine and all. Even after that, then she took the photograph of another one and taking the photograph and submitting to my office, the police stations and all. They are not considered a complaint at all thereafter. Then ultimately, she approached the 9th edition court. She filed a case against 494. So from there, myself, my all family members, the alleged date, they are all the 9 persons have been arrested, and they have been, we are all ignored and bailed. In 1990, I submitted a citation of the Honorable High Court of Karnataka that 494 cannot be tried by the prosecution. So, taking consideration of that citation, the Honorable and 9th Court has discharged this case. Only the PCR was pending. Following that PCR, she continued with the PCR in 1996. It has to be converted to CC case 11 to 16. I'm going to submit this one. 11 to 16. From there, beginning proceedings have been begun. All these things during the pendency proceedings, teams have submitted, made submission to the same photograph for Honorable Court, particular family court, and unfortunately, the Honorable Family Courts have made to believe that I am developed intimacy with a particular woman and all. Then a particular woman also has been summoned, they have also been questioned and she also denied, I am also denied. So ultimately, this became a case, 3 assault cases, 1 case of dowry prohibition, and they were all being acquitted by the Honorable Court. Then the criminal office preferred against them, they have also been dismissed. All these things, it's a very long pending case since our independence. I was not able to go home. On 3-4 occasions, I felt a game of mediation. She said, her target was to convict me. Her target was not to leave with me. Whenever mediation has come, I am not interested to leave with me. Only the conviction is my target. So I thought she did not succeed in this. This is the case. This case has been ended in 2018. This appeal has been filed in 2014. After that, these proceedings only, this became a case, all the cases have been acquitted. 3-4 years I have been waiting, 30 years forward. She is not interested to either contest, she is not interested to leave with me. There are no issue between the relationship between myself and herself has irretrievably broken to my lord. Even waiting for so many years, there is no use in continuing this relationship. I have no intimacy with either woman. I have not contacted any scenario. I have not have any previous relationship with any other woman. I have been gone 33 years of transfer. I have been gone and very transfers to very different stations. No other government employee. I went to Assam. I have earlier to the then I came to Marissa. Then I came to nobody knows where the place is. Hatia is there in Karnataka. I went to that place. I lived there with some difficulty. It is a high radiation area. I have to work in a high radiation area. Then after I was even Awesome. So awesome, I got retired on supervision. Now I had landed this today before this honorable court. Today this honorable kindly dissolve this marriage so that I can live peacefully in peace. There is no whether high desert, she doesn't These are all reciprocal to each other. The cruelty is not reciprocal to each other. It's also the basis of the same point. See what I can argue behind this regard. See, it will continue to she getting assaults and breaking what extent to take place between the children. Honorable the magistrate has granted 20,000 rupees relief to pay per month, and that retroactively out of 20 lakhs rupees, which have been execution paid to her. That what grounds are there to need? What is the method with 60 years? 33 years I have been deserted, I have been subjected to cruelty. I lost my life, I am not able to live peacefully with her. I am not able to discharge my duties peacefully in the office. There are so many, she went and moreover, just forgot one thing. She went and filed so many representations before police stations. She went to very sorry, she went to she Jagdish Shekhar also, she filed a representation there to see that I am sacked from the service. To see that I am sacked from the service. Then I gave a benefit to Jagdish Shekhar that he has no jurisdiction to interfere in the internal of the federal government administration, particularly in private affairs of an employee. So my office has set aside a complaint and dismissed the complaint. Then after this lady went and approached Jagdish Shekhar again, Jagdish Shekhar has referred this complaint to the Union Cabinet. From Union Cabinet, there was a departmental against me. There was so much torture and not even. Then thereafter, I filed an interpretation. Then the Honorable Court was pleased to and injunction against her, imposing prohibition against her from approaching my grounds. So whatever she wants to move to the court. She is not supposed to my employer find any complaint, filing any application. In spite of that, she has been violating this court order and coming to my office 3-4 times. The same Nanjundar which is supposed to be counsel for that. He has sent a notice to my office to sack me from the service because so many criminal cases are pending against me. For departmental inquiries against me, I am subjected to transfer in the court. Rejected all my complaints. These are all happened in 30 years, complete span of 30 years. I was able to get dismissed from the service since the department officers made proper scrutiny of the records and antecedents with the faction figures of the case. That's why they dismissed the complaint. The person, the lady who served off this much cruelty and she wanted to sack me from the service. How this I can expect that continuing relationship. She made a lot of efforts to stop my pension also. That pension clause is not for because criminal cases are against me. I have contemplated against me. Diverse cases pending against me. There were more than 1 year I have been following the pension records office to convince them to release the pension. After they got convinced and they released the pension, I have been paying compensation every time, dutifully, without any pay. So also paying is without any. There's no relationship continuing. Yeah. Because this honorable cannot admit I have to put it in loss of a lot of hardship and injury that you will detrimental to my survival. Still 60 years life, you are let me live this in me. Maybe because of the reason my counsel formally he has failed to convince the entire certain tax to the honorable family courts and they have been convinced Muslim. But this is the position, ultimate position. That is 2014, where thereafter, after this appeal was filed, This is the case of the state. Any other questions you want to be able to answer. I am going to give submit a memo of the criminal cases filed against me. To enlighten this court effectively.
Anything else?
For only case the fact taking into consideration that she is still continuing my house, that is the gross normal continuing, which is I don't think it is reasonable. I have to go to the places where I'm transferred. I cannot continue in the house. Even after keeping away for 20 years, she filed a case in the Act. The runway condition from there, the relief was already been granted. 3 lakhs of this compensation, 20 lakhs of this system, have to pay. There is no other way. Otherwise, they'll be arrested. Which I may not narrate further. Kindly consider all these facts and figures and please grant resolution. Whatever, 3 decades back.
Before.
Rajgopal.
The matter. Kindly pass over the matter, my lord.
Yeah, this is pass over, Mr. It
Kindly
cannot-
pass over the matter, my lord.
Is there, Mr. Rajgopal is there.
Mr. Rajgopal.
Appearing for appellant, my lord. Kindly pass over the matter.
No, Mr. Rajgopal is there.
Yeah, appearing for the appellant. Appearing for the TK Rajgopal, my lord.
Is there, he is very much available there. Mr. Rajgopal, you have muted
Maybe
yourself.
pass over, my lord.
We'll dismiss the case, Mr. This can't go on like this. This is a pass over round.
Mr. Rajgopal, you have muted yourself.
Kindly maybe pass over, my lord.
Your senior is there, Mr. He is there online.
It is dismissed with a cost of 50,000 rupees.
Yes, Mr. Rajgopal, you have muted yourself.
Audio problem.
It's side one, last one.
Last E.
Sir, you are not audible, sir. Rajgopal, sir.
He's muted himself. Tell him. Unmute. Ask him to unmute.
Sir, please check on your side, sir. You are not audible.
Looking at someone. Not providing assistance.
Mr. Rajgopal, we'll call at 2:30.
Yes, heard it from.
Make necessary arrangements. Your Audio, we are not able to hear you.
Has he heard us? Not even nodding his head. Said, yes, he muted himself.
Still there is some problem.
I mean, he needs help. All right. So 2:30 you call. No order sheet.
Hello.
Not Raj.
He's Raj.
Hello, Anil. Hello, Anil. Can you hear me?
Yes, yes.
No, it is all right, Your Worship. There was a mistake.
2:30 we will take it up.
Thank you. What? Court officer. Sir, court officer. Complete
Court officer.
ಹೇಳಿ
Sir,
ಸರ್.
seal number 60.
ಸರ್ ಅದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಹಾ.
ಅದು ರೀಚ್ ಆದಾಗ ಮತ್ತೆ ಸೆಕೆಂಡ್ ರೌಂಡ್ ರೀಚ್ ಆದಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸರ್.
ಯಾಕಂದ್ರೆ ಮೆಮೋ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ ನಾನು. ಇರೋದಂಗಿಲ್ಲ ಅದಕ್ಕೆ.
ಅದೇ ಇವ್ರು ಬರ್ಬೇಕಾಗಿತ್ತು ವೆಂಕಟೇಶ್
ದಳವಾಯಿ ಅವ್ರು ಅಪಿಯರ್ ಆಗಲ್ವಂತೆ.
ಹೌದಾ, ಸರಿ ಬಿಡಿ ಸರ್, ಆಯ್ತು. ನೀವು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಸೆಕೆಂಡ್ ರೌಂಡ್ ರೀಚ್ ಆದಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸರ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಓಕೆ ಸರ್, ಓಕೆ.
Court officer.
ಸರ್ 2:30ಗೆ ನಿಮ್ ಮ್ಯಾಟ್ರ್ ಕರಿತೀವಿ ಸರ್. ನಿಮ್ದೇನೋ ಆಡಿಯೋ ಪ್ರಾಬ್ಲಮ್ ಇತ್ತು.
ನಮ್ದೇ ಸರಿ ಇದೆ, ನಿಮ್ ಕಡೆ ಏನೋ ಸರಿ ಇಲ್ಲ ಅಂತ ಕಾಣಿಸ್ತದೆ.
ಇಲ್ಲ ಸರ್, ಈಗ ಸರಿ ಹೋಯ್ತು ನೋಡಿ. ಅವ್ರು ನಿಮ್ ಜೂನಿಯರ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ ಕೇಳಿಸ್ತು, ನೀವು ಮಾತಾಡಿದ್ ಕೇಳಿಸ್ತಿಲ್ಲ. ಈಗ 2:30ಗೆ ತಗೋತಾರೆ ಸರ್. VC ನಲ್ಲಿ.
30. They have filed the compromise. December 30. The other Mir, Srimati Lata Shetty. Please. What would be matter? We like. We also appreciate. How to fix that? How to fix that? Number 54, Sri T.K. Rajgopal.
I appeal for the appellate, your lordship.
A.T. Gurudev Prasad. Right.
Yeah.
Before.
The marriage of the petition, the respondent took place on 4/6/1992, date of the marriage. Please remark.
Okay, she had a son also. And, 18 lakh, what is he doing? They said, enough. It's agriculture. Yeah, then agriculture. Certain lands for the, I think it's cool.
Mr. Rajgopal,
Yes, your lordship.
you heard the other side. Not able to hear the word.
I am not here. Audible, your lordship. Not audible.
No, appearing from an unidentified location, very easy to say that court is not audible. Who
No,
will-
it's not.
no, we decide, mister, if you are not able to hear, the case will be decided. What is there? Who will lose? You will lose, right?
No, I'm just, it's all right, lordship.
Huh?
No, I'm hearing. It's audible now. Now.
See, the moment we told that we will pass an adverse order against you, we become audible, right?
I'm sorry.
That's the comment.
Sorry, I mean, because I did not hear, it was not audible. I just.
The moment we told that we will dismiss the appeal, we become audible. All right, so.
The respondents counsel submits that you have got sufficient means and he has produced necessary material to show that you have got means to pay the alimony as claimed by them.
Can I just take a lordship, the statement he has filed? The total what's called property that he has got from my father-in-law is about 6 crore rupees. Can I just take a lordship, the affidavit filed by him? Affidavit.
Father-in-law or father?
Father-in-law. Father-in-law has given because of the complaint, police complaint was given, within 9 days he was kept in the custody, police custody, and he got a
Is your client interested in settlement or he is interested in arguing the case?
Lordship, I kindly see that we have the property. Now she has entered into an agreement for 2 crores 28 lakhs. Now they themselves have produced the document. 2 crores. The respondent has entered into an agreement now. 2 crores.
Whatever it is, respondent may enter for 20 crores also. Is your client willing to pay permanent alimony?
Lordship, may kindly see that this is the property the in-law has given. It is not from there. Gift deed executed by the father-in-law. It is about,
very simple, mister. Is your party willing to give any permanent alimony? Yes or no? That's it.
6 crore rupees property she has taken. 6 crores, not 1 or 2 rupees. I have given.
Not answer court question. Is your party willing to pay any permanent alimony?
It is necessary. So much of amount she has got now. No, she has got 2 crores 28 hard cash she has got now. I have produced the document. They've also produced the document. One property.
If your party is not willing to give permanent alimony, you can argue the matter on merits. As simple as that. Question is very simple. Whether your party is willing or not. You have taken a second marriage.
Your lordship, kindly hear me. See,
you don't dispute that you have taken a second marriage.
She stayed with me only for 8 months, and she went got the parents' house. Within few months, they lodged a complaint. within few months from that day.
Can argue this.
Why huge amounts she has got, huge property she has got from the in-law.
Whatever it is, he wants the permanent alimony. If your client is not willing, you can argue the case.
No, Lordship, currently when she has got so much of property and so she has got crores of rupees what called cash with us now. Is it necessary what's called for the husband to pay once again?
You should get alimony from her.
Not like that, not like that. We have got the document, they themselves admit. They have got properties from the father-in-law, and now one property they entered into agreement now. 2 crores and 28 lakhs she has got hard cash with her. Another property, what if it sold means another 4 lakhs she will get. Why she requires now for the alimony when so much the properties have been given by the
Then don't ask us questions, right?
not like that. When so much
please argue. You have been told to argue, please argue. This is putting questions to the court is not argument.
When the document
petition on the ground of cruelty and desertion has been dismissed. Why it should be allowed? Tell us. Yes.
No, my submission, my proposed submission is that a gift deed had been got executed from my from my father-in-law. That was exhibit that is exhibit P1, and that 4 properties were given. The total market value of the property now it's about 5 crore rupees. One of the if you got to one of the properties is entered in agreement now.
Mr. Counsel for the appellant, if you are not ready to give any alimony, you need not argue on that. You can simply argue on the merits of the case.
Kindly see that after I have got 6-7 acres of land now.
Whatever it is, your party is not willing to give alimony.
No,
yes.
There is justification. So much of money property she has got.
That's all right. You now argue on the merits of the case.
That
argue on the merits of the case. We are not on alimony at all. Argue on the merits of the case. If there is only settlement alimony question, you say that your party is not ready for settlement. Therefore, please argue on the merits of the case.
We did not ready. Father-in-law himself has given so much of property.
So that's all right. Therefore, according to you, your party is not ready to give. Yes, not ready means you please argue on merits.
That I make my submission. Yes. The marriage took place on 4/6/1992.
Yes.
He stayed in the matrimonial house only for 8 months. And on 30th June 1993, she gave a complaint against the family members with a jury. Yes. So 30th June 1993. On 7/7/93, that is within 8 days from the date of the complaint, she got what is called this gift deed executed from the father-in-law in the police station. That is within 8 days from the date of giving the complaint.
Who has executed the gift deed?
The father-in-law.
Whose father-in-law?
The father, that is a respondent father-in-law.
Your father.
My father. The total extent of the property is situated near the international airport. It comes to 4 acres and 15 quintals, total acres. And a residential site. The market value of each acre now is around 2 crores 50 lakhs on a conservative basis. 2 crores and 50 lakhs.
Yes.
Out of item number 1, she has entered into an agreement recently, and the total consideration was 2 crores 28 lakhs, and she has received the entire what for extent entire advance amount of 2 crores 28 lakhs. And she has entered into an agreement with regard to other properties now. According to the affidavits 4 and 2 by, as we have given a statement, they are filed for an affidavit. In that affidavit, can I just take an affidavit page number 1?
No, that affidavits are filed only to decide with regard to the payment of permanent alimony. Now that you have said that your client is not willing to pay permanent alimony, we are not on the question of permanent alimony. Please argue on the merits of the case.
No, you also make kindly see that. Now, there was no, a criminal case came to be filed. There was an acquittal order. And this honorable court, when the appeal was what's called decided no, affirmed what's called the order of acquittal no. And this honorable court has categorically held that there is a dispute when the litigation was going on. The sale deed came to be this deed came to be what for got executed from the father-in-law. Then Roshmi kindly see that no, after 28 years she has been staying away from me, 28 or 29 years staying away from me. Roshmi frequently what called the respondent's contention is that I have taken a second marriage. You will also make kindly see that when I got married, what was responding to, I had a father aged about 75 years and a mother aged about 65 years. The object of marrying the respondent only with a view to see that she will take care of the aged parents. And immediately after when she went, stayed for 8 months and went back to her parents' house. Thereafter, she did not perform any conjugal rights conjugal right to the parents. The aged parent could not get the food. I had no other option to go in for a marriage, and I feel very bad about it. And that because of the conduct of the respondent, I had to take what is called a second marriage. So second marriage was not with a view to enjoy myself. It is only for the purpose of enabling the wife to perform certain duties to the parents, in-laws. Now, they should not do anything but for 8 months. There was no contribution whatsoever by the respondent to the in-laws. So this marriage, second marriage I have taken only to help my parents through some sort of a comfort in their house, but not for my own enjoyment. And she did not feel bad about it. This is the reason, not that she got married when because to enjoy certain comforts like that. For my parents, there was nobody to take care of now. That compelled me to go in for the second marriage, not for any other purpose. And the second wife is the poorest, comes from a very poor family. And now she has been with us. The fact of marrying, taking a second wife is only for this reason, nothing else. If she had only continued, this problem would not have been there. Roshmi kindly see, not a sentence is there anywhere expressing the intention to come back to the family fold. She has not given, there is no what is called any evidence whatsoever in the record. Now she is very comfortable now because ancestral properties are there. The father-in-law's clothes of his properties are there now. She is enjoying. And I lost the parents because so much of worry they had, and the worry due to worries only they died. So you know this, my respectful submission is that now taking the second marriage is only for the necessity of providing some comfort to the aged parents.
Your parents were staying with you?
Parents died long back.
Huh?
Say the parents have stayed long back. Second wife he did, and with
No, no.
no,
When your marriage had taken place, were your parents with you?
they only compelled a son to go in for second marriage because there was nobody to help them.
When you married,
Parents were there. Yes, waited parents were there.
Are they with you?
They were with me. Parents were with no. This lady was not with me. She left.
The question is very simple. When you married the respondent here whether your parents were staying with you?
Yes, my parents were staying with me.
Who is PW2? PW2 is your father.
Yes, PW2 father.
He says that he is not staying with you. And he does not know your whereabouts. That's what he says.
That is not correct.
Please read the cross-examination. That is not correct means. Read the cross-examination.
For their comfort. Yeah.
Which cross-examination of PW2 or DW2?
PW2.
PW2 is the lady.
First 4 lines you read.
Raj.
Where is the gift deed?
Gift deed exhibit P1.
Therefore, that contention of yours is not correct because your father has said that he was not staying with you.
He could not go anywhere. He was certain aged person. He could not go anywhere.
Not go anywhere means what is the evidence on record? He could not go anywhere means that we don't know.
Well, also may kindly note the exhibit P1. They've also produced exhibit D1, the typed copy. D1. D1.
He says, I don't know whereabouts. He says, I don't know. That I bring my child up. Because my son has become second. Therefore, I wanted to give 4 acres here. I said, I don't know whether.
Yes.
Can I just take my lordship to this court's order, sorry, judgment in appeal, criminal appeal. Your lordship may kindly come to exhibit down. Exhibit P16. Your lordship may kindly come to exhibit P16. This honorable court will not call allowing the appeal, dismissing the appeal, and just read only few sentences. Respondents are examined as PW12, and the evidence reveals that there is a civil dispute between the parties and there are 2 suits, etc., etc. And the evidence also discloses that the second respondent said to have compelled to execute the registered CD, giving a big picture in favor of BW2. This gift deed is subsequent to complaint filed and appears to be during the course of investigation. I was completely what is called under the control of the police station for about 2-3 days. And they took me from the police station to the sub-register office. Otherwise, no person will give 4 acres, 5 acres valuable land to any person. And this shows that what's called the pressure brought upon me to just execute this deed. 4 acres, we will 8 acres, 8 crores. Does she require 8 crores?
Mr. The ground is cruelty and desertion, not 8 crores.
So far,
Have you read, Mr. Counsel, have you read the terms of exhibit B1? What your father says?
This is not drafted by what to call me, by the what to call my father. It was not drafted by what was some document writer, but close to him.
What is said by your father in that? Have you read it?
You have not read this at all. You also may kindly see that this document was got drafted by what's called by deed writer.
When have you taken the second wife?
No, I took the second wife after she left what's called left the matrimonial house. And after this.
Was it after the birth of the child or before that?
No, long after the birth of the child. No.
Long after the birth of the child. This gift deed was executed.
That is on 30th. It was gifted 30th June 1993.
That is before the birth of the child.
Yes.
Before the birth of the child.
I think that it was before the birth of the child, or I think before the birth of the child. I'm not quite definite about it. According to me, it must be just before the execution of this day.
When was the child born?
I don't know that much of information.
You are the father, you don't know the
I know, as an advocate, I do not know. And that information is not available in the reports now.
That information is not available on record.
Whether it may be in some cross examination. I just find out 1 minute. Just take it. It is like this.
Yes. When was it?
I just read it. ಮದುವೆ ಆದ 8 ತಿಂಗಳು ಮಾತ್ರ 1ನೇ ಆರೋಪಿಯ ಮನೆಯಲ್ಲಿ ಇದ್ದೆ. ನಾನು ತನ್ನ ತವರಿಗೆ ಹೋದಾಗ 1ನೇ ಆರೋಪಿ ಮಗುವಿಗೆ 3 ತಿಂಗಳು ಆದಾಗ ಬಂದು ಮಾತನಾಡಿಕೊಂಡು ಹೋದರು. ದೂರು ಕೊಟ್ಟ ನಂತರ ನನ್ನ ಮಾವನ ಮನೆಗೆ ನಾನು ಹೋಗಲೇ ಇಲ್ಲ.
When is the date of your son's?
He is now 21. Now he is 21 years now exactly.
Therefore, you don't know what is the date.
Yeah, I can just correct it. No problem.
Huh?
I can just collect that. No problem.
20?
I can collect it. There is no problem.
20th March?
Huh?
20th March 1993. You're sure?
And the gift deed is dated 30th.
And in the gift deed, it is said by your father that the gift deed is being executed, but because you have taken a second marriage.
He was an illiterate person. He did not go through that. Even family members did not know the gift deed. Only when the entries were made in the OTC, he came to know about it after 9 or 10 months afterwards now. This was signed on the police station, not openly. He had no mind to give the for any land. It was donated in the police station. He was so much compelled.
Let him argue water. Yes, Mr. Anything else?
But also, this is the main reason his brother is there. He is a person who has completely spoiled the life of both the wife and the husband. Also, may kindly see that he knew there are very valuable properties now. He formulated strategy, and it is because of him this what's called gifted came into being. Otherwise, she would now simply come back to the matrimonial house. And now he has got he wanted to knock off the very valuable properties now. And he got found out by giving a complaint to the police now, and by keeping in the police detention now. This gifted came to he is not at all bothered about other welfare of the sister. He is only interested in the knocking of the property, very valuable property. No, that lady did not have her own intention to just what is called to stay in her parents' house. No, he made that lady not to live in what called parents' house. He is the person who spoiled the whole the life of the what's called petitioner husband and their families. .498 case, not a single allegation or there. Single allegation is there. 498A. That is what the Honorable High Court has just said that. Simply they were all the three aged parents, and this what called petition parent no got frequent to the police station. Everything was done in the police station. It is because of this deed what's called the relationship between the what's called parties suffered what is called strain, and as a result of that what's called the two what's called families got separated. He was taking care of the wife very well. Can anybody give 4 acres land what's called to voluntarily to any person? 2 or 4 acres means it's about 6 crores, 6.5 crores.
You completed your submission.
That's all. That's all. That's all.
Where he has admitted? Where he has admitted that he has. ನಮ್ಮ ತಂದೆಗೆ. ಯಾವ ಪ್ಯಾರಾದಲ್ಲಿದೆ? ವಿಚ್ ಪ್ಯಾರಾ? Start. When? Recorded on 23. 2011, your cross-examination. Which date?
Page 5 sir. Page 5.
From the second marriage. This exhibit P on that second wife's name is there. Exhibit P1. ಅದರಲ್ಲಿ ಎರಡನೇ ಮದುವೆದು ಹೇಳ್ತಾರ್ರಿ ಯಾರನ್ನ ಮದುವೆ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರ ಇದೆ ನೀವು ನೋಡುದಿಲ್ಲ ಏನಿಲ್ಲ ಇಲ್ಲಪ್ಪನವರ ಮಗ ನಾಗಮ್ಮ ಮಗಳಾದ ನಾಗಮ್ಮ ಇಟ್ ಇಸ್ ದೇರ್ mentioned Nagamma's name is there. Don't look into the papers at all. Fourth page he has said ನಮ್ಮ ತಾಲೂಕಿನ ಪಕ್ಕದ ಗ್ರಾಮದ ಪಿಲ್ಲಪ್ಪರವರ ನಾಗಮ್ಮನನ್ನು ಎರಡನೇ ಮದುವೆ ಆಗಿದ್ದಾರೆ ಅಂತ Yes.
Total extent of. Yes. Filing of objects.
R1 is what at least it is mentioned that is his wife. Number? Yes. Huh? Exhibit. Yes, Mr. Rajgopal, you have to reply. Yes, Rajgopal, anything in reply?
Nothing, Lordship. I just made submissions. Yeah.
Not be necessary. Not be necessary.
Sir, 58, A. G. Narendra, A. Krishna Swami.
Also emailed the submission. It's not coming.
58, none for the appellant even. Last date also you see, Mr. Huh? None present. What other this thing? Other date also, none appears for the appellant even when the matter is called in second round. None had appeared on behalf of the appellant on 15/11/2022 as well as as 14/11/2022 as well as 15/11/2022. It appears that the appellant is not interested in prosecuting this appeal. The same is accordingly dismissed for the prosecution. 8 and 58.
59. YSH Reddy. Is Praveen Kumar.
Right? What has happened? Decree granted? Granted. What ground? Delay. Restitution. So still interested in restitution? Yes. Huh?
What petition is that? What happened? That also.
Whereas the government wanted to people file it. Based party in that. Also, the given an undertaking with their police was followed by the UFO. They are undertaking to take me back after getting a better job. That was considered by the lower court.
You are working.
No, I was working before my husband. I wrong pattern. On a contract.
Not claimed any maintenance.
Maintenance, I'm not getting it regularly. I filed petition to that. I got it. As of now, the 10,000, which I'm not getting it regularly. But because that cash even and more building. Specifically, no thing use of any cash or one more round of it.
What did you do for 9 years? Why did you file it only when a petition for divorce was filed by the husband?
During that period.
What happened to petition for divorce?
That was the. Cases for maintenance during that period. So there are a lot of efforts being used by relatives and mentioned. I think there was no response to the all relatives have been visiting.
still back to square. What is the such justification for keeping silent for 8-9 years?
There were efforts.
9 years.
My relatives were mistaken. Each and I had 5 maintenance petitions. My I have my age mother, which is and nobody can look after me. And in his family too, all his sisters are married, and he and his mother.
So has he filed an appeal against that order?
Where is the judgment in the divorce petition? Judgment in the divorce case.
Husband's it was year 2017, it was filed in the year 2012, and judgment was in the year 2017.
No, 1 minute, 1 minute. You made a statement that I could not file a counterclaim in that petition because that was already disposed of, where I was placed ex parte.
Yes, ma'am. Yes, ma'am.
That was not disposed of.
Then I understood.
That was not disposed of.
That time was not disposed.
Then you just now made a statement.
Yes, I contested afternoon coming to know that there is a diversity filed against me. I came to know, I report and I.
You made a statement that I was placed ex parte, therefore I could not participate in that proceeding, therefore I not get a counterclaim.
Whoever that form, it was at the time I was not aware. Later on, after filing my
Give that judgment. The judgment in that
at 20 states.
give that copy. When did you lodge this criminal complaint?
It was in 2005. It was in 11.
Then she came in year 2007, she finds an intern. Yes, I know what that means. If I'm doing this 2007. Right side, he was to be. 2007.
Anything else? To go back. If you wanted to go back, so you would not have filed a criminal case. Then this thing. All of them went to jail because of you. You would not have antagonized your husband like you would not have antagonized your husband and his relative like this by filing a complaint. See, I mean, this sequence of events, Mr. 2004, you got married, 2005, criminal case, then 2007, maintenance, then 2012, he files a divorce, then you file, 2013, you file this restitution.
Go the way. And first time it was classified in Villa Code, and next time it was for the demands were moving. In your way, had to go before the jurisdiction and that is my interpretation. My never thought.
Never.
Could be.
So don't stay together and spoil the relationship. Huh? Be happy.
Now
Huh?
nobody are there. Yeah.
Nobody else?
It's only his mother.
Mother.
I'm looking at it.
Yes, to take care means. Criminal case, what, 498A?
Yes, ma'am.
What happened?
It was dismissed.
Oh. Dismissed. All of them were acquitted, right? Yes. This appeal. Under section 19(1). The family court side has been filed against judgment and decree dated 4th of February 2015, passed by the family court, by which petition filed by the appellant, stroke wife, under section 9 of the Hindu Marriage Act, seeking the relief of restitution of conjugal rights, has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the marriage between the parties was solemnized on 11/6/2004. In what time they stayed together? In what time they stayed together?
Nearly for 6 months.
The parties for 6 months. How long? Admittedly, after the marriage, the parties resided together for a period of 6 months. Thereafter, the appellant filed a filed a criminal case against the respondent and her family members in the year 2005. When was it dismissed? Stop. Paragraph. Thereafter, sometime in the year 2007, the appellant filed a petition seeking maintenance from the respondent. The respondent thereafter in the year 2012 instituted the proceeding under section 13 of the Hindu Marriage Act. The appellant thereupon filed a petition sometime in the year 2013 seeking restitution of conjugal rights. Full stop.
The petition under section 13 before family at Bangalore.
Acha.
Which is filed with Mysore family court.
All right. Respondent filed the petition under section 13 in the year 2012 before family court at Bangalore, and then the respondent thereafter is the appellant filed petition under section 9
At Mysore.
at Mysore before the family court at Mysore. The respondent entered appearance and inter alia contended that the appellant, after the marriage, had demanded a separate residence and had refused to take care of his old and infirm parents. Full stop. It was further pleaded that the appellant herself had deserted the respondent on 19/12/2004, and thereafter filed a complaint in Mahila police station by making false allegation which resulted in acquittal of the respondent and his family members. Full stop. It was also pleaded that that respondent has already filed a petition seeking dissolution of marriage before the family court. And as a counterblast, this petition seeking restitution of conjugal rights has been filed. Paragraph. The family court, on the basis of the pleadings of the parties, framed issues the appellant examined herself, whereas the respondent examined himself. The family court wide impugned judgment dated 4th of February 2015 inter alia dismissed the petition on the ground that delay on the part of the appellant in seeking restitution of conjugal rights disentitles her to the relief. Disentitles her to relief. Paragraph. Learned counsel for the appellant submitted that appellant is still interested in joining the matrimonial home. It is also submitted that the petition filed by the respondent under section 13 of Hindu Marriage Act has been dismissed in the year 2017. 2017.
It's 2007.
2017. Full stop. It is also it is on 12th of July 2017, right? 12th of July 2017. It is also submitted that the family court has failed to appreciate the evidence on record in its correct perspective. Paragraph. We have considered the submission made by the counsel for the appellant and have perused the record. Admittedly, the marriage between the parties has been performed or was performed on 11/6/2004. It is also not in dispute that the parties are residing separately since
2005.
there was some date mentioned. You have mentioned, written some date.
Certain in the month of December 2014. He left December 2004.
Admittedly, the respondents are the parties are residing separately since December 2004. Full stop. Full stop. In case the appellant wanted to join the matrimonial home, she ought to have filed the application seeking restitution of conjugal rights at the earliest available opportunity. However, the respondent instead of filing, the appellant instead of filing a petition under section 9 of the Act chose to file a complaint in Mahila police station against the respondent and his family members. Full stop. In the aforesaid complaint was dismissed and the respondent and his family members were acquitted from the criminal case in the year 2011. Thereafter, full stop. After filing of the complaint against the respondent and his family members, again instead of seeking the relief of restitution of conjugal rights, the appellant again filed a petition seeking maintenance, in which a sum of rupees, how much? 3,500 was granted to her by way of maintenance. Full stop. The respondent thereafter
23 days. And there is a delay.
What have you written? The respondent thereafter instituted paragraph. The respondent thereafter instituted a proceeding under section 13 of the Act seeking dissolution of the marriage in the year 2012 before Family Court, Bangalore. After a period of 1 year, the appellant instituted a proceeding before the Family Court, Mysore, seeking restitution of conjugal rights. Full stop. Thus, from above aforesaid narration of facts, it is evident that application seeking restitution of conjugal rights was filed after an inordinate delay of 9 years. 9 years. Full stop. Section 23 of the Hindu Marriage Act 1955. 1955 deals with decree in proceedings. Section 23 within bracket D of the Act reads as which is relevant for the purposes of controversy involved in this appeal, reads as under Code Section 23D. Full stop. Thus, it is evident that if there has been any unnecessary or improper delay in instituting the proceeding, the court is court can refuse to grant the decree. In the instant case, there has been a delay of 9 years in instituting the proceeding. The family court, therefore, in the facts and circumstances of the case and on the basis of material available on record, was justified in refusing to grant the decree for restitution of conjugal rights. To stop from the evidence on record, it is evident that the appellant was not keen in joining the matrimonial home and had in fact had left the matrimonial home herself in December 2004. The family court therefore has rightly dismissed the petition under Section 9 of the Hindu Marriage Act, paragraph. The aforesaid judgment and decree, which is based on meticulous appreciation of evidence on the court, does not call for interference in this appeal. Line below, for the aforementioned reasons, we do not find any merit in this appeal. The same claims and will be hereby dismissed.
Number 60. Here, Mohan.
Your Lordship, while a memo of retirement on behalf of the appellant, they have taken NOC wakalat, Your Lordship. On 10/11.
As amicus. Yes, Mr. No week's time. Huh?
Admitted in the hospital.
Whose husband?
Appellant is admitted.
Appellant. The GR Mohan Learned Counsel submits. Seeks leave to withdraw, permitted to retire, right? Whatever. And Mr. Venkatesh P. Dalwai, Learned Counsel, Learned Amicus, submits that the appellant has engaged. What's your name? Engaged? Mr. Rudresh. Full stop. What's your name? Your Rudresh, no. Huh? Huh? But he says appellant is in. Achha. Mr. So and so Learned Counsel submits that.
Appellant has instructed him to appear.
That appellant has instructed him to appear in the appeal, and she is hospitalized. He therefore, you want to file wakalat? He therefore pays for. No, he has filed wakalat.
Yes, filed today.
Instructed him to appear, and this thing he is filed wakalat, right? He eventually write adjournment, right? Pays for adjournment. What happened there? Appellant is not going to tell you how to argue, Mr. Appellant is not going to tell you how to argue the appeal. That you will have to. Information, no information. No. Oh, unable to give material information. Appellant prays for adjournment. This next week. Don't seek an adjournment, will not adjourn. Mr. Mohan has been kept waiting because of you. Who will compensate him? He is a busy lawyer. Several issues of public importance have this thing.
In fact, the appellant had made baseless allegation against me at the last hearing date, Your Lord. I never asked for any fees from the appellant.
Oh, no, why
you want
you
to
should
engage a
ask?
service of legal service authority.
Okay. Oh. Yes. Good that you came. Otherwise, it would have been dismissed in second round. Good that you came. Husband appeal. Claimant's appeal, like, right? Husband appeal. Enhancement of compensation. No. Okay, why have you filed an appeal? Wife's petition has been allowed, right? Huh?
Alimony is there.
Permanent alimony.
Alimony. Claim for
You should be happy, right? You should be happy that you are not required to take care of your children. She has been brought up by your wife. They have been brought up by your wife. You should be happy. What else do you want? No permanent alimony. Oh, that's why. Only against that order. How much has been awarded? Yes. More than reasonable. What do you do? What do you do? What? She is a lecturer, right? Professor, what do you do? She? So he is also saying she. Both she. No. Not having. So you are seeking permanent alimony from your wife, along with children, right? Huh? Nothing. Rightly run. Mister, there's no point in prosecuting. When was this decree passed? When the marriage took place? 2001. You don't even know. Right? So after 21 years, you want to stay with your wife in her house, right? Because you don't do anything. There will be a problem to your safety, Mr. Your children have grown up sons. We don't know what they will do with you. Huh? So better to stay away and be happy. Yes, go ahead. So 8 lakhs should not have been granted. Fine. What else? Huh?
There is no counterclaim.
Hey, Mister, there's no point in this thing. Setting aside, do you understand the futility of the exercise after 21 years of marriage? That really means he is unemployed and his whole object is to somehow penalize you. I mean, just to cause trouble for you. But it must be a nuisance in life. Don't do anything, right? You're not doing anything. Huh? What are the allegations of cruelty? What did he do? Huh?
In the class actions, he admits that his relatives and they are aware that his work profession in after that only she will give the consent. She has to give the consent. Married. Other allegation is he is using affecting the character and using the good. To do this, there are no.
What document? So, if you suspect the character of a person, what document? She should not have been considerate enough not to lodge, right?
2 children. is it? What are they doing? You are a lecturer. Lecturer in?
He's a professor.
Professor.
So that's all right, but what about the counterclaim? Ah. That's all right, but Mr. C, we are trying to now, please understand the futility of this situation. 21 years have passed. It's not possible for parties to live together, right? So you are as it is, you are a professor. You give it a lecture or whatever. I mean, you give up the claim of permanent alimony. This man will be, who is a non-employed, who is unemployed, will be happy. No, of course, we are trying to bring about, otherwise, see, we will have to deal with this. The decree has to be set aside, matter has to go back then. Again, you will be remaining life, again, after 10 years, you will be before the High Court appeal pending. That's what we are. Yes, mister, but she is your wife, right? You have to pay something. How much will you pay? No question of present. This all you understand, right? I mean, the parties cannot stay together now after 20 years. There is no point in this thing. We will reduce it to some extent. We will make it 5 lakhs, right? 3 lakhs, 3 lakhs each to your children, the children. Son and daughter, 3 lakhs each. That's fair. Then nothing, no submission. You should be happy, right? You don't do anything and try, you are this thing only 6 lakhs by making payment of 6 lakhs, you will get away. If you understand, mister, there's no point. Even if we allow your appeal, I mean, whether the parties can stay together.
It could be only another round of litigation, that's all.
Otherwise, we will decide your appeal on merits. Nothing. As it is, there is nothing in this appeal. You will get a not, you are not paying. Yes. If she is working and getting the salary, then you say that she is getting. So that's why decree should be set aside. What is the argument? She is getting, supposing 2,40,000. So therefore, decree should be set aside. The argument. Dismiss it. We'll dismiss your appeal. Why to wait for tomorrow?
Reducing the maintenance is something I will ask my client.
We don't need his permission. You understand, right? Ask me what ask. You are working in a gambling club. And now you don't do anything.
Whereas the learned judge said that, no, there is no counterclaim. Whereas he said that there is no counterclaim.
That issue number 2 is there.
In spite of that, he says there is no counterclaim. Where is it?
You have stated that he is guilty of cruelty towards
Last line.
and has not claimed any relief of by way of counter.
Yes, Mr. And it's not a case of accidental omission. Para 7, you see. Para 7, page internal page 8.
Point for consideration. Second point.
Second point. Open the file here only. The way he is looking at it. Not
Point for consideration. Second point for consideration. That is with regard to counterclaim. There is a, in spite of that, he says that there is no counterclaim.
just now he has read it, Mr. Para 14 of the judgment, last 3 lines on page internal page 22. You are not opened the judgment, right? Opening here in the court. Huh? No, the way you are seeing it, we can make out that you haven't read it fine. You are just opening it here.
That's only point number 1. That's no answer point.
So unable to find para 14 of the judgment. Oh, we feel surprised.
Where is the answer for point number 2? What they have done it. He holds that there is no claim for restitution of conjugal rights. Para 14. Why don't you read that?
He is unable to find it out.
It's a counterclaim. There is a point for consideration. In spite of that, he says there is no counterclaim.
If we ask you to read it, you have given it back without reading. It's very strange. and then para 20. Para 20 then. Point number 2. He has not even answered point number 2. Obviously, when the finding of the court is that he has not filed a counterclaim, he could not have answered point number 2. So read para 20. Is it so difficult, Mr.? You are looking at us as if we are asking you some question in German language or French.
He has not considered, Mr.
You are looking at us as
He is
if
not considered, not considered.
no, he has considered. All you would canvass is that yes, trial court has considered. Thank you. What can be done? Please read para 7 again. Para 7. Para 7, para 14, para 20. Read it one by one. And aloud so everybody understands that we are not putting any difficult question which you can't understand. So he has noticed here para 7, then read para 14, last 3 lines, again read it aloud 3 times. 3 times. So that it sinks in that he said that there is no counterclaim. Para 14, last 3 lines. Though he has stated, read it 3 times. Aloud.
Last line, last 3 lines.
3 lines.
Though he has stated.
Read it, though he has stated. Please help. Please help, please help. Read it, though. Again read. If you wish to read it again, read it again. Even though. So there is a finding that there is no counterclaim. Read it again, though he has, again help him, show him where. No, read it again. I mean, we don't know how can you argue like this. Again read, though he has stated. And then para 20. Mr. This is too much, Mr. It's your case. We are required to tell you read this para, that para. This is the judgment under appeal part, not part of the record. Great. Wish we had that privilege and liberty when we were practicing as advocates. By now, the judges would have thrown the file over our heads. So we are telling you how to read, what to do. Read para 20. I am surprising.
Okay. Not that he is even okay. He is even okay. Not that he doesn't know. Still they don't want to consider. That's it.
So what is in view of my finding on point number 1? So where is the finding on point number 2? No finding. Thank you for your assistance. Thank you. That's it. Anything else you want to read? Now, what about the finding that no relief of or restitution of conjugal rights by counterclaim has been filed. So what is it? Stray.
Where is the rejection of counterclaim in the operative portion?
That is also stray sentence, which you will not find in the operative portion. Huh?
If
So
it is
why
not,
is it so
if it is
difficult,
not there, if
Mr.?
it's not there, Mr. Why don't you advocates understand that? It is not there, not there.
Say so that it's not there. You cannot bring it there. By looking at us, you can't bring it like there. Huh? Sorry. Why should you be sorry? You say so. What we expect is that at least say so frankly that it's not there. We are using. Huh? No, this is not. This is a appeal.
No, you are wrong. You are here to assist the court. It is not that you are here to defend the order.
No question of supervisory jurisdiction. This is an appellate jurisdiction. This is not a writ petition under Article 227, Mr. This is an appeal. So what if we have supervisory jurisdiction? So what? We can correct the order, right? And say that counterclaim is dismissed. It has to go back. What to do? You have a liability for rest of your life. So he is very happy prospect of going back. Tomorrow evening you will go back.
63 years.
You want to go back.
That to rejoin both of lived in nearby. Because they 63 years and 55 years.
You are unemployed and she is employed.
That's why. How is your bar business going on, Mr.? Closed or is still going on? Lost the license to run the bar. Don't do anything means. How are you surviving? If you don't do anything, how do you survive? How is he affording you as a counsel if he doesn't do anything? Set aside.
We'll ask him to find out if they are ready to give up their own. Ask them to pay the joint amount. So counsel, find out from your party whether they are interested in that alimony or not. If they are not interested in the alimony, you speak to him and he may be ready. His grievance appears to be only alimony. He is not interested in taking you back or leaving. Find out from her. If you give up the alimony, probably they may agree for some settlement. They are not ready to pay, mister. You should understand whether it's for children or for the wife. They have to pay. He doesn't question his money. Otherwise, we will send it back. You want to take instructions or shall we proceed to pass orders?
Yeah, not day after.
Tomorrow. Find out from your client. You also.
Tomorrow, Pause. What? Not entrustment of inquiry, right? Huh? Yeah. What have you done? You must have realized that it has proved very costly to you, right? 2,500 rupees has proved very costly to you. What is the ground of challenge?
The ground of challenge, as last time your lordship said, that may not be the whole ground which can be, what can come to my hand. One of the grounds as before my lord earlier. Because I was tried by the special court. But I have been acquitted. And the observation of the trial court is because on the face of the record appears to be lost, falsely implicated. That is the order of acquittal.
He will be held guilty in a department plan.
Yes, you can.
What's the position of law? You can be held guilty in a department led by. Criminal case, we need not tell you the basic.
I think that's one of the circumstances in my favor. I may not
No favor.
fully rely on that. But subsequently, that
Standard of proof is different.
yes,
Fine.
the probability is not in the departmental inquiry beyond reasonable doubt. No trial.
Nothing happens. What next?
That has been in fact confirmed that has been confirmed by the respondent also. Once again, the observation of this court also may not on the basis of the record in between after the acquittal and before confirmation of the acquittal belongs to the articles of charges were issued. The complainant and the shadow witness and the investigating officers have been examined. 1, 2, 3.
Gives a finding that the prosecution has not proved the case. That is one thing. What is the finding? This law begins to be a false case. Then we will be defined.
Yes.
The post-inquiry recommendation pursuant to the recommendation of Honorable the board has taken a decision of.
You have to tell us some basic facts. Straightway jumping to criminal case.
Complaint is crime number 10 of 2006 was lodged. Alleging that the work of order of the complainant was supposed to be forwarded by the petitioner to give his higher officer.
Criminal case.
That's crime number 10 of the for the offense punishable under 7 and 13(1) of Prevention of Corruption Act. Because the allegation is because the work order was issued in the name of the complainant was supposed to be forwarded to the higher officer by the petition for further action. In order to forward the file to the higher officer, he has paid a demand for sum of 3,000. Thereafter, scaled down to 2,500. But the post registration of the complaint was the formality of the pre-draft was wrong. But in the pre-draft proceeding, because the 2,500 rupees currency handed over to the complainant with an instruction because it has to be passed on demand. But on the same day, wrap up the day. But as for the case of the prosecution, because the accused petitioner has received a sum of rupees 2,500 smear with powder. And after counting the currency notes, he has kept in his right. But the pre-arranged signal was given to the waiting investigating agency. But thereafter, after the police people, along with the other officials, rest to be fought. And the amount of 2,500 should have been recovered from the right bank. But the only was the hand wash. The hand wash from the coding format and so on. But after the sustaining the prosecution fact and the prosecution, but in order to bring in the guilt of the accused, examined 7 witnesses. But after marshalling the evidence of the special court, while the judgment dated for 14 May 2003, it made it for the May. Acquitted. Petitioner acquitted. But the entire case appears to be very, very doubtful and it appears to be a false case. But after the acquittal, articles of charges were issued against me on 30th September 2009. But I offered my defense statement in reference to the articles of charges. The presenting officer, in order to do the articles of charges that the petitioner has accepted, the demanded and accepted the illegal gratification. But the inquiry was conducted by examining 3 witnesses. Of the 3 witnesses who have been already examined before the trial court, were examined before the trial officer. But the complainant has been examined as PW2. Shadow witness has been examined as PW1, and the investigating officer has been examined as PW3. Because the inquiry officer very strictly arriving at the conclusion, discuss only the chief examining part of the presenting officer and does not even refer to the various admission parts which were elicited during the course of the cross-examination. Though the shadow witness has turned a both side, if evidence has been taken as part of the evidence has been taken as acceptable and it can be given due consideration. The inquiry officer, while the report dated 30th of July 2014, 30th of July 2014, the held that the petitioner is found guilty of in this part. In between, in the intervening period of this, the acquittal and the final or the conclusion of the inquiry of this, the state has preferred an appeal against the acquittal before this honorable court. In a criminal appeal number 878 of 2008. 878 of 2008. But the appeal was heard and dismissed by order dating 7th March 2012. 7th March. Plus, based on the inquiry report, plus the Honorable Lukaka, while the recommendation dated
recommendation dated 2/8/2014. With 2014, recommended for the major penalty by removing the delinquent from the service. Major penalty of removal. But the recommendation dated 8. Plus it happened, so belongs to by the time the recommendation was made, the delinquent had attained the superannuation. In the month of April 2013. But in view of this, the circumstances where the major penalty of removal must be given effect, plus the board has ordered from the petitioner by way of a show-cause notice to offer its explanation. Plus after the explanation was offered by the order dated 20th May 2015. 20th May 2015 as per Annexure A. Annexure A. The entire pension has been withheld. But the power of my lords imposing the penalty plus that you have been drawn from regulation 171 of my lords employee service regulation 99. Plus under section the regulation 171. Last date I had given only the regulation 171. So it is the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from the pension of the board or part of any pecuniary losses caused to the board if in a departmental or a judicial proceeding, the pensioner is found guilty of a grave misconduct or negligence during the period of its service, including service rendered on re-employment after retirement. Basically, I am my lords before this honorable court, the first ground is my lords I have at the beginning of my argument and saying my lords. Though the order does not speak in a clear term that the honorable, the tenor of the judgment, the observation of the trial court as well as this honorable court is in the form of the honorable acquittal, and those the witnesses who have been examined before the trial court and the documents which have been exhibited, documents have been exhibited before the trial court where the paid material which were placed before. Plus the second submission is towards I have put in the 35 years of service.
So what first submission is that in view of acquittal in criminal case, inquiry could not have been held.
But if it is honorable,
I don't know. You have, it is for you to formulate the submission. We are asking you what is the submission.
But my submission is since I have been
Honorably acquitted, therefore no charge sheet could have been issued.
confirmed So the inquiry should have been, should have not been continued, or I should not have been guilty of the offense.
View of honorable acquittal in criminal case, penalty could not have been imposed.
Please. Plus the second.
What is second ground?
Plus the second ground is, I have served the institution for a period of 35 years. 35 years. Plus after the retirement, the pensions, the withholding of the entire pension is shockingly disproportionate. Plus I am conscious, my lords, the judgment of this honorable court. In many cases, my lords, says the quantum of the penalty or a punishment cannot be interfered by this court, even though it is found that it is a shockingly disproportionate. The only option is, the matter has to be remitted back to the disciplinary authority to redo the entire, whether it can be done or not. So I'm conscious of that. This honorable court. That's my humble submission is the pension, the provision of pension is only to the at the back end of the life of the person who can survive for having rendered his service for so many years. But even if for a moment, my lords, the offense is been proved, whether my lords, the major penalty, the form of virtually, my lords, hanging a person.
Hanging a person? What do you want us to say? That corruption is an accepted norm in public life? What is it? You are a public, like it's a charges of corruption, be it 5 rupees or 10 rupees or 3,000 rupees. This corruption, right? Demanding money. No, in the context of disproportionate thing, we are evaluating. At first issue, we will deal with whether it can be imposed on you. But how can you argue disproportionate? We don't. Fine. Yes. Case law. Yes. What else?
The regulation 171. Though it empowers the authority to lodge withholding of the entire portion of the pension or any part of it. Let's my understanding of this 171 is, my lords, this it can be invoked only, my lords, the act of the delinquent has caused a pecuniary loss to the be invoked for the purpose of this case is the another. Last count on which we were taking intelligence of this honorable court. In fact, the last time we have been directed, but I made a submission to this that the KPTCL had its own service. But as and when there is a service for the institution, the reference under section 14A is not my learned friend submitted that even the service law of the KPTCL itself is embedded in 14A. So that I will not have any arguments on that point.
Yeah. We continue tomorrow.
Yes.
Yes. Okay, why? It will continue tomorrow. We don't know whether it reaches or not. Tomorrow it will continue.
Land acquisition.
Special land acquisition officer. 28/1/25. Check land. Section 5. Huh?
Yes.
Record also.
Yes. Correct.
We will take it away otherwise.